Announcement of judgment pertaining to ideal bench. RFA 27 of 2023.
Appeal stands dismissed. I stands disposed of accordingly.
Mention, please.
Item, sorry. 4-8. Supply. Yes. What do you want? Yes, prayed for by learned counsel for the applicant. 2 weeks further time is granted. Application date. Next steps upon respondent. Yes.
Please, Your Lordship, I beg to mention item number 20. I'm appearing on behalf of Ahmed. Your Lordship, for some difficulties, my senior won't be able to be present today. Kindly. Item 20. Kindly fix any day before vacation, Your Lordship.
Okay. 20. The prayer of learned counsel list after. Yes.
Yeah, please, Lord. So I beg to mention item 9 from Delhi list. Item 9. I may be allowed to withdraw this petition, my lord. That's fine.
You are Mr.
Ahmed, my lord.
Prayer of Mr. Yes, Mr. Ojban.
Please, Lordship, I beg to mention AB, which was filed day before yesterday. Let the matter come up by tomorrow, Lordship.
Why before this bench?
And anticipated bail application, Lordship.
Go to senior bench.
Please, Your Lordship. I beg to mention item 26 of the daily list, Your Lordship. Your Lordship, the CD was called for and it has not yet been received, Your Lordship.
He did not receive list again on.
Urged, Your Lordship.
It's an interim, I think. 16, 7.
Interim may be continued.
Interim continue.
16, 7. I beg to mention for listing tomorrow this interlocutory application, which is connected with the main AB, which is listed before your lordship tomorrow. Published. I beg to mention item number 1. I would like to withdraw the same mail.
Item number 1.
1.
Yes. You are Mr.
Publish Ahmed. Yes, sir.
Yes, Ahmed. Learned counsel for the petition.
Publish.
Yeah, please, Your Lordship. I beg to mention item number 42. In this case, KP Pathak was appointed as a amicus curiae. He is out of station.
Leave application was submitted.
Yes, leave application was submitted.
Learned counsel for the. Place the matter again on. Just give a date.
Much obliged.
Item number 4, my lord. Here in this matter, another matter is fixed on Monday, my lord. Next week, Monday, my lord. That will be fixed together, my lord.
List along with.
With
Item.
PA number, I have the number, I will provide it, my lord. Together with the
On Monday.
on Monday, my lord. Yes.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 33. As far as section 33. As far as section CD not received.
It's rather interim, lordship.
Interim may continue.
33. She did not
17,
receive interim.
Hey, please, Your Lordship. Lordship, I beg to mention item number 8. In this case, I am the informant in the case, Your Lordship. My senior is due to some personal difficulty, he will not be able to appear today. So, Your Honor, my humble prayer is that Your Honor, maybe allow me to appear in my personal capacity. Your Honor. I'm the informant. Your Honor.
Among other things, some suspected animal within bracket dog hair was found. And accordingly, after arrest, they have remained in custody for the since then. Having regard to the nature of the allegations, further detention of the prisoner appear to be necessary. The prayer for bail stands allowed. Petitioners shall be released 50,000, 2 sureties each.
Judicial Magistrate, First Class, Nagaon.
Cooperate with the investigation. I took.
Much
With the
appreciated.
evidence.
So nice.
Please, your lordship. Lordship, it's an application under 482 BNSS. So basically, the story is that the accused petitioner is the owner of a home care society, that is Apun Home Care Society. Lordship, it's an NGO giving care to patients. She engages girls, and she sends those girls to the home of the patients. So the accused petitioner is not the actual main accused in the FIR. The FIR is in page 14 is the translated copy, 14, 15, and 16 is the vernacular, your lordship. May I read? Page 16, lordship. সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা একমাহমান আগৰ পৰা মোৰ ছোৱালী শ্ৰী মনীষা দাসৰ ঘৰত স্থানীয় বাসত প্ৰায় এনে থাকে। তেতিয়া মই ছোৱালীজনীক সোধাত কোনো কাৰণ নোহোৱাকে ভাল পাই থাকে বুলি মোক কয়। যোৱা ইংৰাজীৰ 6/6/2026 তাৰিখে আগবেলা প্ৰায় 11 মান বজাত মোৰ ছোৱালীজনীক আৰু কেইবাপাৰৰ গাঁৱৰ ওচৰৰ কুসুম দাসৰ ছোৱালী ৰিংকি দাস আমাৰ ঘৰৰ পৰা ওলাই পঠিয়াই দিয়াত মেডিকেল কাম দিব বুলি আমাৰ ঘৰৰ পৰা ওলাই পঠিয়াই দিয়াত গুৱাহাটী গণেশগুৰি এটা ঘৰত ৰুমত বন্ধ কৰি ৰাখি থৈছে। পদকীয়া স্থানীয় এজনে সোধাত আৰু এনে এজন পুৰুষ ৰুমটোত বন্ধ কৰি থৈছে। সন্ধিয়া পৰ্বলৈকে দুয়োজনী ছোৱালী ঘৰলে উভতি নহাত আমাৰ গাঁৱত হাহাকাৰ হোৱাত গাঁৱৰ কেইবাজন ডেকা লৰাই গুৱাহাটীলৈ গৈ বিচাৰ কৰি গণেশগুৰিত ৰুমৰ ভিতৰত থকা গম পাই ছোৱালী দুয়োজনীক উদ্ধাৰ কৰে। So basically, your lordship, this
Where is the notice that you received?
notice is in page 22, lordship. 21 and 22. After receiving the notice, which is annexure 3, first notice we complied and we went to the police station and recorded our statement, lordship. And thereafter, again on 11/6/2026, while we recorded our statement, the police handed over us the second notice under 35(3) BNSS, which is annexure 3A, page 22, lordship, the second notice. And thereafter, what happened? The accused petitioner was sick and she was taken to a hospital for injection. She was suffering from weakness. So we sent a application to the police IO stating that we could not appear before the IO on 16/6/2026. We intimated the IO, but the IO kept on pressurizing the accused petitioner to appear. And as such, we approached before this honorable court, lordship.
One person already arrested.
One person, Mahima Das, who
already
is the named accused, has been arrested already.
And she was brought on 10/6/26. The notice was sent to him on 11/6. So some prima facie materials were found.
Mahima Das,
You might be that man and woman, unnamed man and woman mentioned in the FIR.
actually, Lordship, what happened in this, I am the owner of Apun Home Care Society. The society registration is also in my name, Lordship. And then what happened? These two girls were found by Mohima Das at our home, but we were not. I do not know Mohima Das personally. We only have the telephonic conversation, Lordship. And the thing is that when these two girls came over, I asked the girls that whether they have procured the IDs, they have brought along the ID proof with them or not. They told that they will get the ID proof through WhatsApp from their mother. And suddenly in the evening, some boys from her village came and told that these girls won't be working with in our NGO further, and they took the girls, both the girls, and one of them were allegedly minor, but it was not in our notice, Lordship. This is the actual fact.
What is your NGO? What document is there?
I have the registration certificate. Actually, the registration certificate original has been seized by the police on 10/6/2026. I have the photocopy, Lordship.
Yes, right, Lordship.
Also, while the police personals went to that particular society office, the society office also wrote that this NGO is authentic. The society office put their seal and sign.
No, what is the purpose of your society? What do you bring those girls there for?
Care society for taking care of patients. The patients who does not have much family members, or the patients who does not have people to look after them, we provide them home care. Lordship. That is the purpose of the society.
Reading page 24, grounds of arrest of the arrested person. I'm not quite sure what offense has been committed. No allegation that they were being used for any immoral purpose or anything like that.
That is
Just that
correct.
the girls were brought there for providing employment. So what is,
After
what is the offense made of? Not that they have been cheated or whatever. Thing appears to be there. All right, but let's see the CDM.
Lordship.
Provide some interim protection. Standard counsel for the petitioner. LPP. This is an application in the so and so. Page 23, brief of the case. Second paragraph. Where it is submitted that the petitioner is not an FIR named accused, and she is the owner of an NGO called Home Care Society, which is registered with the authorities, and the purpose of the NGO is to provide home care facilities by supplying persons to take care of patients in their homes. Is connection the NGO receives girls and by their families for the purpose of employment. Full stop. All for the CD. Having regard to the nature of the allegations. It is provided that the petitioner before after first submission, you also said that pursuant to notice under section 35 received from the IO, the petitioner had previously appeared before the IO and her statement was also recorded. Also, subsequently, she received another notice, but she could not appear before the IO due to ill health. Because of which she now apprehends that she may be arrested. Full stop. Having regard to the above, it is provided in the hearing that in the event for arrest in connection with 1,000 to sureties. Further directed that the petitioner shall appear before the IO within a period of 10 days from today. In her statement. Just again on
7.
Next.
shall not try to intimidate the witness.
Lordship 482, Lordship. Okay, FIR from page number 11, Lordship. The type of Lordship. Actually, there was a fight between two groups, Lordship, in Rudramuni Dhaba, Lordship, because the Dhaba owner was a Muslim, Lordship, but he kept Sanatani culture, some photos, Lordship, but the petitioner was not present only, Lordship, nor he is the owner, not Lordship, of the Dhaba, Lordship, nor the employee, Lordship. The incident occurred, Lordship, at around 9:30 p.m., Lordship. But from 8 p.m., Lordship, he is in home only, Lordship. I have annexed also, Lordship, the footages of the CCTV, Lordship, from page number 18, Lordship.
What?
Lordship, the incident occurred, Lordship, around 9:30 p.m., Lordship, as per Azhar, Lordship, but he was in home only, Lordship. From annexer, Lordship, page 18, Lordship, annexer B, Lordship, I have annexed also, Lordship, that he is in home only, Lordship, from 8 p.m., Lordship, till the next day, Lordship, 12:59 p.m., Lordship. Page number 18, Lordship.
What is this?
CCTV footage, Lordship, that he's in home. The time is also there, Lordship. The fold page, Lordship, the fold part, Lordship. The time and date is also there, Lordship. But he's ready to cooperate, Lordship, with the police, Lordship, if he's.
The allegation is assaulted by iron rod, forks, chairs, fish cutting knives, and long spatulas.
Maybe, Lordship, but he's not present in Lordship. In that Dhaba, Lordship. The proof is evidence there, Lordship. He's ready to cooperate, Lordship. And ready to show all the CCTV footage also to the police, Lordship.
This CCTV footage is 8 p.m. Incident is 9:30.
Next is also there, Lordship. 8:51, Lordship. Next page, Lordship. Then Lordship 10:22. Lordship. There is no Lordship record that he went outside, Lordship. Lordship, he's ready to cooperate with the police, Lordship, and show all the footages, Lordship. But he's afraid, Lordship, he may be arrested, Lordship. That's why. He's ready to cooperate, Lordship.
The incident took place on 9:30 p.m.
Hmm? Hmm.
That his bedroom footage is also there, Lordship. Page number 22, Lordship. He's in home only, Lordship. But he's ready to cooperate, Lordship. And he's not FIR name accused also, Lordship.
You may have a backdoor also. What do we know about this?
But he's ready to cooperate, Lordship.
You have a footage of different times, but not of the relevant time.
But Lordship, only the outside only the CCTV footage is there. CCTV camera is there, Lordship.
What is the distance
That is
between
what-
Dhaba and this, how his home?
We don't know.
Lordship, 4
But the
kilometers.
allegation is of attempt to murder,
Yes.
and it has been lodged by the chairman of the municipal
So he's not
corporation.
FIR name accused also, Lordship.
Hmm?
Not FIR name accused also, Lordship. Police went to his home, Lordship, maybe some misunderstanding, Lordship. But he's ready to cooperate, Lordship, if he gets interim, Lordship.
Who are you? You are not the owner of the dhaba.
No, yes, Lordship, not the owner, not the employee, Lordship. Lordship, and in the dhaba also, Lordship, if the CCTV footage are seen, Lordship, he is not present only, Lordship.
Who is the owner then?
Zoinur Ali. Accused number 1.
So Zoinur has set up Rudramani.
Yes, Lordship.
Hmm. Who are you then?
His name is not in the video.
So he is the Lordship, actual Lordship from, he does business in Rongya, Lordship. There he does business, Lordship. Maybe some misunderstanding, maybe does, Lordship, but he's not present only, Lordship. No connection only, Lordship. So he's ready to cooperate, Lordship. He's ready to show all the footages also, Lordship. But if the CCTV footage of Rudramani Dhaba also seen, Lordship, there also he will not appear, Lordship.
Learned counsel for the petition and learned an application on so and so. The facts of the case are that the informant who is described as the chairman of Rongya Municipal Corporation got into an altercation with one Jainur Ali, owner of Rudramani Dhaba, situated at Rongya. As the said dhaba owner had set up some pictures of deities in the dhaba, despite himself being a Muslim, and as a result of the government raising the said issue, the accused persons named in the FIR assaulted the petitioner, assaulted the informant with weapons and caused serious injuries. Para learned counsel for the petitioner submits that the present petitioner is not an FIR named accused and is in no way connected with the aforesaid incident. He has also referred to photographs of certain CCTV footages of the relevant time, showing the petitioner to be present at his home at the time of alleged occurrence. Full stop. Order submitted that the footage of the place of occurrence will also reveal that the petitioner was nowhere present at the time of occurrence. So it further submitted that the petitioner shall cooperate with the investigation and provide the CCTV footage available with him to the IO. Call for the CD. In the interim, it is directed that the two sureties shall be for the IO 10 days. Try to intimidate or again.
May I please, my lord. The 482 application, my lord. I am Foijun Nisam, my lord. FR space 18, my lord. Page 18, my lord. There is 6 number of accused, my lord. I am for accused number 4, my lord. Foijun Nisam, my lord. Next, my lord, relevant person is space 19, my lord. There's a long FIR, my lord. My allegation is that, my lord, in page, my lord, 20, my lord. Page 20, my lord, para 8, my lord. Then, my lord, para 12, my lord, here is a allegation, para 12, my lord. That on the mother of the informant Mujibur Naha Begum, Runima Begum had filed miss case number so and so, setting aside the mutation order, that it passed in favor of accused number 4. This is in my name. That so and so, the accused number 1 had submitted the first document, accused number 1. There is a one cell lead also, my lord, page 27. Cell lead was done Mobubul Haq and Fojun Nisa, my lord. That is
Main allegation is para 14, page 21 also. Is not 5 9.
accused number 4. I am accused number 4, my lord.
4.
That is against accused number 5, my lord. I am purchaser, my lord. I am one of the victim also, my lord. Now,
Rising out of CFI, alia one case is listed before lordship that a circle officer. That's fixed on 18/7. But
there, my lord, page 46, my lord, there is a civil case, one title suit is pending, my lord. Between my lord Mohibul Haq and Suraj Setia, my lord.
That case, what was the order? That was for the circle officer,
Circle officer, that was interim was granted to the circle officer because
7/7.
Public service.
being a public servant, her role was limited, Lordship. But in here, in this case, Lordship, they have manipulated and fraudulently obtained a sale permission, Lordship.
Yes, my lord, I am purchaser, my lord. If some money,
Allegation against you is that you submitted a false no objection of this Begum.
that is there, my lord, allegation. How can I file, my lord, false objection? I am purchaser, my lord. If something was done by the office, my lord, there is a process server, they have served to, and there is a sign of Gaubura. I am only purchaser, my lord. I have no authority to no objection certificate to give, my lord. Because I am also
Of course, you
purchaser.
have no authority. That is why it is false.
Yes, my lord, that is not I submitted, my lord. I only purchaser, now I am victim,
Anyway,
my
that
lord.
is
My
the
money
allegation
issues, my
against
lord.
you, that in connivance with accused 1, 2,
Yes.
and 3, you submitted a false petition in the name of Nirupama Begum.
It is their submission, my lord. How I submit, my lord? This
That
type
is
of-
their submission. This is your submission. So
Yes.
we have to see the CD.
Yes, I am purchaser, my lord.
It is required.
And already, my lord, I am appeared before this, my lord, authority, my lord.
Very good. What date is that fixed?
18/7.
18/7.
My lord, interim, my lord.
No. Yes, it is ready.
Please, Lord. Anticipated bail application, my lord, by FIS page 13. May I read, my lord? If FIR registered voluntary causing heart failure 11772. My lord, in fact, 109, so far as 109 is concerned, may not come, my lord. In fact, my lord, we were two petitioners before your lordship, the Troilo Gogoi and and Bokul Dori, who is the brother of the candidate from BJP in the last election, assembly election for the constituency Sivasagar. And what was happened, my lord? The incident was, alleged incident was took place previous night of the election, my lord. So what happened? The two persons, two victim, my lord, they tried to, using some unfair means, motivated the voters and trying to malign the name of the candidates from BJP, my lord. And some scuffle was there, but what happened? The named was mentioned in the FIR, my lord. No one has present in that incident, my lord. But to with malafide intention, my lord, only they mentioned 4 persons' name was not even there at the time of incident, my lord.
Yes.
And in fact, my lord, immediately after the lodging of the FIR, Bokul Dori was lifted by the police and interrogated him thoroughly, and thereafter released him. And thereafter, no police personnel searching for them. And after declaration of result, the police again searching for the petitioners, my lord. And in fact, they hide their guilty, my lord. They admitted the victims, 2 persons, in the hospital, my lord. And there's no grievous hurt. The informant is the PA of the Akhil Gogoi, and he is the election agent at the relevant point of time, my lord.
Going to the FIR, also they are Condition was critical and referred to the civil hospital from Shivsagar to Dibrugarh, Lordship.
But my,
This is registered under 117.
Yes,
Voluntarily crossing grievous, not
182 is not there.
7 years.
7 years.
but the investigation matter, and in fact, petitioner number 2 has already interrogated by the police prior to declaration of result, my lord.
So if you are brother of ruling party, why do you apprehend arrest?
But he's not
Uh-huh.
win, my lord. In the fifth hour responsibility.
Third learned counsel for an additional an application under if X is alleged in the FIR or that the date of occurrence on 9/4/2026 at during night time when the informant along with his case were returning home after having dinner. They were attacked by a group of miscreants, causing serious injuries upon the informant and his associates, which required their hospitalization. The present petitioners were among the said miscreants who assaulted the informant and attempted to kill him.
Not the informant, my lord. Say Bidyut Soik and Pranjal Gogoi. Informant is different, my lord.
But if informant is different, in place of informant and his friends, you write Vidyut Soikia and
Pranjal Gogoi.
the present FIR has been lodged by another person, namely Omlanjoti Gogoi. Came to learn about the incident and visited the injured persons. Full stop. Whose statement who went to the police? Which of you?
Lordship?
Said one of you went to the police.
Or Lordship, Bokul Dori. Petition number 2.
Is submitted by learned counsel for the petitioner that the petitioner number 2 had. He received notice or he went voluntarily?
Directly lifted him from the house, my lord. This directly lifted him from the house.
Number 2 was taken by the police from his house and thereafter released after questioning. So why do you apprehend arrest now if you are
Now searching for me, my lord.
however the police are again searching for well as the prisoner number 1. Further submitted that the case is registered under section 117 within bracket 2 stroke 109 NS. Section 191 within bracket 2, stroke 126 within bracket 2. And none of the said offences except section 109 BNS is punishable for more than 7 years imprisonment. BNS relating to attempt to commit the offence of unlikely to be attract in the present case. The case is not all for the CD. The event of the 5th year before the 10 days. So will not try to intimidate. Just
Obliged.
Please, your lordship. Lordship, in this case, my lord, the petitioner and the victim, they have already compromised the matter. Petitioner is the son, is the daughter-in-law of the victim, my lord, opposite party too. Now they are saying that they are living very peacefully, being an old man and in the same family, my lord. The trial court, my lord, initially passed an order sentencing 1 year. My lord, thereafter, the appellate court reduced it to 6 months. And they have compromised me. Offense under 324, Spanish sentence.
it compoundable.
My lord, now in terms of honor, I have also some judgments. My lord, the honor is that it can be because the victim is an old person, my lord. Now she is
No, this is post conviction.
yes, my lord.
Yes. So
My yesterday I have also received an affidavit.
Lordship, I have filed an affidavit.
That
Lordship,
is-
no, we understand all that. What is the power of the court after this conviction? In revision, what is the power?
My lord, the honorable court can, my lord, can reduce it to the sentence already undergone, my lord.
What judgment have you brought?
But I am referring Murali, my lord, Murali versus state represented by Inspector of Police, my lord.
And this is a revision petition,
Lord. Here it says, my lord, if
not a criminal petition under 482 or 558. Anyway, let us see what judgment you have.
I'm
But Supreme Court has compounded in all the cases, those are cases of the Supreme Court. Supreme Court can. 142.
Yeah. But my lord, there was also revision petitions.
No,
My
but
lord,
High Court did not do that.
High Court has, that is why, my lord, the Supreme Court.
Yes. So go to Supreme Court.
In this case also, my lord, she has already undergone some period of imprisonment.
So let the same procedure be followed. Also go to Supreme Court. You first show us our power. That after conviction, whether we have the power to reduce.
When it is also clear that, my lord, paragraph 12.
Was the compromise for petition anything filed before the appellate court or trial?
No, my lord. it
Trial
is
court, no.
there. No, after,
After conviction, you became wise.
my lord.
After it was dismissed in appeal. Only after that.
Appeal not dismissed, appeal it was reduced. Appeal was not dismissed, reduced.
Already reduced.
Reduced 6 months. My lord. Anyway, my lord, since my friend has filed affidavit, my lord.
You
Maybe
can file whatever you like. We have to go by whatever powers we have.
this case also, my lord, my lord kindly
This is a revision petition. You can challenge the decision on ground of propriety, correctness, legality.
anyway, my lord.
On
may
those three grounds, we can
may I place
interfere.
1 week time, my lord, to produce some
All
other
right, to
judgment.
satisfy us that we have the
Yes,
power.
my lord, I will satisfy. I have some judgments. Today I am not, my lord.
Hard learned counsel for the petitioner and counsel for the respondent number 2. Three. Who is 2?
To my lord,
My husband of the is respondent number 3, Lordship. He has died in 2017, Lordship. Thereafter, she was simply dead.
earlier
3.
husband died, now implemented the victim, we have implemented.
It is submitted that a compromise petition has been, compromise has been reached between the parties. You have filed any affidavit? No.
Lordship, yesterday I have filed affidavit, Lordship.
This
It is
regard
not
and
on record.
affidavit has been filed by the respondent number 3, which is not on record. Registry is directed to place the same on record. It is further submitted by learned counsel that he shall place certain authorities regarding the power of the High Court to reduce the sentence after the conviction and sentence has been upheld. Upheld post conviction and sentence by the trial court and the first appellate court. The matter given.
With the 21-7. Can it be 21-7? Obliged.
I am deep.
Item number 12.
May please your lordship.
Yes.
The matter relating to
dispute regarding the date of joining also.
Date of?
Date of joining in the college as a lecturer also. In Morongi Mahavidyalaya, it was previously it was private college, Gauhati aided college. Later on, it has been taken by the government, provincialized. So let me see. Page 27 also.
Other side is has appeared.
Yes, my lord. We have a response number 2.
So page 27. Letter in regards to petitioner number 2 also. It had been page 22 annexure A. Well, it has a long background and 2 high court cases have already been disposed of and deliberation has been, that is the speaking order has been passed by the Director of Secondary Education. And after all, that is the respondent number 2 has filed the FIR and which was, that is the submitted police submitted final report and she filed objection against the final.
What was the FIR about? What is the FIR?
FIR Lord, annexure U 64 Lord. An issue has already been settled by the government laws, especially the education department, by a holding inquiry committee. 64 page number, annexure U. May I read, Lordship? In the affairs, he has suppressed the order of the Director of Secondary Education and order of the High Court also. Nothing has been mentioned in the affair. And against this affair, police has submitted the final report. And
Where is the final report?
is 72 also. Annexure W. And moreover, the principal has already retired also. Petition number 1.
Here on criminal liability here, retirement will not cure it if it is there.
Yes. But one thing is that already government has, by holding inquiry, that is the passed the verdict also while story loss. And forensic report also with on the basis of forensic report, the final report has been, that is the issued by the police. Page 76.
So where is the impugn order now? After final report, the magistrate's order.
Magistrate order is page, that is 76 Lordship. 14, 11, 17 Lordship. Informant Pragya Soika is present and filed a petition stating that she has objections to the final report is submitted by the police. Hence, in view of the petition filed by the informant, registered a complaint case on the petition, bench is directed to take steps. Accordingly, FR is rejected. Lordship may see. Annexer Q, page 57. 2-3 orders have been passed by the Director of Secondary Edition. That is the final order, Lordship. Annexer Q, page 57, Lordship.
Lecture?
Page 57. Annexer Q. This order is very important, Lordship.
But my learned friend has relied the page number is not matching with my petition, my lord. There is some differences I have found, my lord. This
Okay.
petition has been sent by post. And after receiving this, and my learned friend has said that 57 annexer Q. But here in my petition, 57 is annexer T.
Who has filed objection then?
An objection filed by me on
Oh,
the basis of this
huh?
petition.
There, then you did not find any difficulty.
No, but now they have relied, no, because the petition who says I have received, my lord. On the basis of that, I have filed this. But the paging number is different. Because I have appeared in this case as a legal aid counsel. Yet as it may, my lord, my humble submission before the lordship is that this is a case for cheating and forgery.
Page,
So
paging
since
is
after lodging the FIR, the case has been investigated and final report has been submitted. And on being received the notice, the respondent number 2 has filed his Narazi petition. And thereafter, the London Crime Court has registered a complaint case. And 2 witnesses has been examined under section 300 of the CRPC. This witness has clearly said that the.
After that, cognizance was taken.
Yes,
After examining the witnesses.
that's why my humble submission, since prima facie there is a case, so the quashing of the FIR and charge sheet at this stage, my lord, is not warranted at all. Since the cognizance has been taken, the trial may be concluded, my lord.
Lordship in
At
the
this stage, my lord, the interference of this honorable court is not warranted at all. My humble submission.
Lordship.
And in my objection, I have already annexed the witness evidences, my lord. Page 108. What difference is it?
Lordship in the FIR, that is, they have not stated anything about that is the order passed by the Director of, that is the secondary education, as well as order passed by the Honorable Gauhati High Court, Lordship. And order, that is the issue. Latest is this FIR has been passed after.
Where is the order of taking cognizance? Have you annexed it in the objection? LCR is here.
Here has come up, my lord.
You have not challenged the order of taking cognizance by the magistrate,
Has not been challenged.
although you filed a petition after that. You filed this petition on 3/11/18. Order is 11/10/18. This is a criminal petition. The entire proceeding has been challenged.
Lordship,
But even then, even though you have not specifically challenged this, since this is a criminal petition,
Lordship.
subsequent event order of taking cognizance after recording the depositions, how is it an abuse of the process of the court? You have to put out a case. I will fix this for hearing.
Yes, Lord.
Since every
It may be fixed, Malo. This is in 2018 matter.
Yes, fix it.
Basic thing here is that, well, since the after examination of the witnesses, the cognizance has been taken. Let them face the trial. They have not done nothing, so they will.
May be able to make out a case where because of the other developments should not be made to face a trial again. Just to show that you have to show it would be an abuse of the process of the
Yes,
court.
yes, Malo.
Otherwise, things appear to be in order, normal course. And final report, Narazi,
Then examination of the
cognizance,
witnesses, then
examination,
cognizance has been
notice,
taken.
Two district
seems
level,
to be in order.
Lordship, two district level committee has already been inquired in the matter, Lordship.
In
As
that
per the
matter,
direct-
my lord,
as per the
negative-
direction of the High Court. And in the FIR, she has stated nothing, Lordship.
that is only-
FIR is totally absent of the previous development, Lordship. Why? It is a suppression of material fact. Because on the basis of the order passed by the two writ petition, that is the Honorable Gauhati High Court ordered for inquiry and dispose of the appeal. But that has to be, there is place in the FIR, Lordship.
It is altogether different.
And
different-
delay filing the FIR, no, that is the justification, Lordship.
Additional PP, Mr. So-and-so learned. Yes, for respondent number 2. Here has called for has been received, hence admitted for hearing. List the appeal hearing on given date after vacation.
What's up?
Number 13.
Wait, please. The matter was fixed today for arguments. But the quashing petition, I, the petitioner, am a bona fide subsequent purchaser of a property in PS Bharalmukh. Now, the FIR has been registered. The allegations made have been against my seller. I am a subsequent purchaser. May I just show your lordship the FIR and the complete lack of any allegations against me in the said FIR? Lordship may have.
Query is not before your lordship. You have not.
There he was, lordship may have previous order. His diary had come to your lordship and
Was returned back for updation, Lordship. Lordship may peruse the last order. 14/5/26.
Yes, return back and updated case diary. Where from is it supposed to come now?
CID, Lordship.
but even on the last occasion, it had come from the CID.
Understood, it was sent back and to be resubmitted with by after updatation. What was the case about anyway?
Lord, I'll just give your lordship a brief.
No, just give a cap because without the CD, I don't think we can, but we just want to
No,
recap
If
of
your
what was.
lordship believes that the CD is necessary, otherwise I'll give your lordship a brief of the case.
That is
FIR.
what we are saying. We don't want to hear you for 1 hour and then decide that the CD is necessary.
Definitely, your lordship. I am a bona fide subsequent purchaser. The FIR only mentions the sale deed by which my seller had purchased the property from the previous person. There is nothing mentioned in the FIR about me, my sale deed, or forgery of my sale deed. Thereafter, this matter is actually a civil dispute. There is a prior title suit pending in respect of this particular property, in respect of the so-called forged alleged sale deed and my sale deed pending before the learned civil judge senior division. The FIR has been registered after and during the pendency of that civil suit. In that civil suit, as your lordship will see, exact same allegations of forgery have been taken up by the respondent number 2. Respondent number 2 here claims that he actually has title over the property by virtue of a will executed by one of his predecessors in interest. Today, there is nothing in the FIR against me. I have never been issued notice. Investigation has been pending. So-called investigation has been pending for the past 2 years. No charge sheet has been filed. And this is effectively a civil dispute which is being turned into a criminal dispute. There are further aspects of the matter which I'll show to your lordship.
Receipt has not yet been filed.
Not been filed for the
So
past.
then we have to see the CD only. What is,
But
if the CD reveals
may I?
material justifying the proceedings, then
Definitely.
can we say that it is purely of a civil nature?
But even allegations are not there in the.
Lordship, there are gross suppression of material facts in this.
I'll show
Right.
that cross separate.
Then the CD would be even more necessary.
Who has suppressed
If that is the-
what material facts.
All right, heard, Mr.
Lord,
Spencer.
May I just interject for a moment?
Yes.
This aspect of the case diary not coming to your lordship, this has happened previously on many occasions where directions have been issued and lordship will see the previous orders. Directions have been
No,
repeatedly
CD had
been
come,
issued-
not, it was there.
repeatedly been issued to the state. And
No,
it
CD
would
was
not-
there on the
for
last day.
some reason or the other. Again today, so thereafter again on the next day, my apprehension is again on the next day, the CD will not come for some reason or the other. And
Okay, we'll
but-
fix a date specifically only for CD, 25th. It will only be for CD and then we'll fix it for hearing the next date, right?
25th of.
I am grateful. I am deeply grateful for that.
Not Mr. Swen.
Senior counsel, I'm led by senior counsel, Mr. Das. He is not available on this 25th lordship. After
We are only fixing it for the CD. That is the part we want to take care of first,
I am deeply grateful.
because every time that will come up. So and so, so and so, so and so.
24th lordship.
Hmm.
The respondent
It
number 2, how is the concern?
Appears from the previous order dated 14/5/26 that the learned additional PP was directed to return back the case diary and to submit the updated case diary today positively. However, it is submitted by learned additional PP that the CD not available. So, the investigating officer is CID. In CID is hereby directed to produce the updated CD on 24/6/26 without fail. List the matter on same date for production of the updated case diary.
And thereafter the matter will be fixed for hearing.
That will say on that day.
Matlab,
Please, Your Lordship. Matter may be passed over for the time being. So this sir will argue the matter.
Please, Your Lordship. So see, here is a case. What happened, Lordship? Where, Lordship, two cases parallelly running in a court, in the same court, under same section, against the same person, arising out of same allegation, Lordship. Firstly, Lordship may kindly peruse page number 26. This is the FIR filed on 37/2022.
Let us, he's started, let him come. Yes, what was the case?
Lordship may kindly peruse page number 26. This is the FIR. The case begins with this FIR. This was filed by the victim lady on 37/2022, alleging some 498 charges. And thereafter, Lordship, now Lordship may kindly see page number 32. 32 in vernacular, this is the CR case. After 7 days, on Lordship, 6th of August 2022. Immediately after 7 days, this CR case has been lodged for recovery of Steedhorn. Thereafter, Lordship, what happened?
Recovery of?
Lordship,
Recovery of what?
Steedhorn.
Steedhorn.
Thereafter, Lordship may kindly peruse order. Everything will be clear. Page number 59. Page number 59, order passed in the CR case. Complainant is present along with one witness, namely so-and-so. The witness is examined, honored so-and-so, heard the learned counsel for the complainant, peruse the materials on record. After such hearing and perusal, I have found sufficient grounds to proceed against the accused Hamidul Islam for commission of the offense punishable under section 498A IPC. This is the order passed on 10/9/2024 in the CR case. And now, Lordship, what happened? After the investigation of the PRC case, Lordship, FIR, when the investigation completed, search frame under 498A, and Lordship, now order may be perused.
Charge is framed under what section?
Yes, Lordship, PRC 790. This order may be perused. The 19/10/2022, page number 67. Page number 67, the case record received is up to for the trial and disposal. Peruse the case record and case diary. The IO has submitted the case in search sheet under section 498A IPC against the Hamidur Islam and Yunus Ali. Hence, the cognizance taken under section 498A IPC. Cognizance of 498A has been taken both in the cases CR case as well as the PRC case. Now, Lordship, in the same court,
Has this
under the
been
same
pointed out
section-
before the court or not? Did you file any application there?
Yes, I have filed, but this is declined. Therefore,
Where is that order on that
yes, Lord,
application?
an interim order has also been passed by the Honorable High Court for staying the proceeding of the CR case. CR case now.
You're not
it is-
answering a question.
It is, Lordship,
My question is, did you file the application bringing this to the notice of the court? That another
yes,
case?
yes, I have filed
FIR
before the
case.
lower court where the
Yes.
cases,
What
both the
order has
cases are
been passed
running.
on that?
Lordship,
What order has been passed on that?
yes. No, no order has been passed.
Order has been passed.
That's why
Where is your application?
application is in the court, Lordship.
You have not annexed. Where have you stated? Is how can two cases continue together?
Lordship, he has not brought this issue to the before the honorable court, Lordship, learned court below, and the cognizance has taken. SARS is yet not framed, Lordship. While framing SARS may be framed under another section also. And while framing SARS, if that order is placed before the learned court below, that may be considered, Lordship. And Lordships kindly see the conduct of the petitioner, Lordship. There is already an order existing for passed under DB case. It was passed on 19/7/24. As of now, not a single penny has been given to the.
We are not concerned with that.
DB case, here no whisper of DB case in my petition.
Don't burden us with unnecessary things. We are on a limited point.
My learned friend is saying that SARS has not been framed, but Lordship may kindly peruse the last page, 72. Finding sufficient materials against the accused person's formal charges under section 498A/34 IPC were framed and read over and explained to the accused persons to which they pleaded not guilty and claimed to be tried. This is the last page. This is the search framing order, Lordship. And in the Steedhorn recovery case, that is the CR case, Steedhorn has already been recovered. Thereafter, the case is running under section 498A. My humble submission is
FIR
that
is dated 37.
Lordship, search framing order is at
No, FIR
Yes, Lordship,
37.
37. It's subsidiary.
Where is the complaint?
Lordship, complaint
28.
in vernacular 32. And in the page number 34, the list is given for the recovery of street horn, what to be recovered. And it has been already recovered.
Yes, what is the provision of law? When FIR and complaint in both are present. Yes, petitioner, you have to answer.
Lordship,
What are you looking at?
the provision, Lordship.
The provision on which your case is based is unknown to you. You have to search for it now. Yes, go to your library and find out the provision.
Applies.
Next item. Back at 2.
May it please, your Lordship. Lordship, this application has been filed from jail, Lordship, and this person was as per custody certificate, Lordship. He already served more than nine years, Lordship. Conviction was under section 4 for 10 years, Lordship.
So there is a POCSO case, probably service is not complete.
On the last occasion, steps has been taken, Lordship.
This is what, suspension?
No, Lordship, suspension was not there, appeal against the conviction order. Because Lordship, the fact is Lordship, almost 10 years is he is serving. So Lordship, steps has been on the last occasion, the Honorable Court directed and we have taken, but Lordship.
Did not file any application for suspension of sentence despite so many years in jail.
No, Lordship, this case has been filed from Legal Aid Service Authority, Lordship. Kamrup Metro District Judges Courts, it has been forwarded lately. Lordship,
Is there a bar for the Legal Aid Service Authority to file an application for suspension of sentence?
suspension, there is no bar, Lordship. In another
So what
one
can
and
we do now in this appeal? We can hear the appeal, but it has to be complete.
Lordship, yes, that is the admitted fact, Lordship, and the procedure, Lordship. And this case has been forwarded to the Legal Aid Service Authority on March 2025. Judgment is of Lordship 2018, Lordship. And this has been forwarded by this Honorable Court, Lordship.
So no report from the IO. See, no report has been received till then. No. It has been routed through
Yes.
concerned police station.
16, sir.
My prayer is, Lordship, there is a mandatory provision in POCSO for service of notice, Lordship. The fact is custody certificate I have submitted on the last occasion. It is
What is mandatory provision?
for service on respondent number 2.
Yes, that is what we are trying to ascertain. But two, through the OC of Petri police station, no report of service has been received. Learned additional PP submits that he will take instructions and apprise the court accordingly on the next date fixed. In this case, the appellant has been sentenced to 10 years imprisonment, out of which he has already completed 9 years
10
10
weeks,
months.
19 days.
And 19 days.
Okay.
And therefore, only 41 days remain for him to complete the sentence. Having regard to the urgency of the case, so is appointed as amicus curiae to represent a respondent number 2. The event that the respondent number 2 for service does not appoint an counsel of her own. Also, place the matter again on Monday. Okay. You talk and get the notice served at least.
Yes.
Professor DDM Professor.
May I please, my lord? My lord, by this criminal petition filed under 528B NSS,
Objection to objection to. May I please, your lordship? We had filed our objection yesterday only. I don't think I have told them to tag it in the record. Probably it has not yet come. Because we have got very short date to file this reply. So, and that is required to be approved by the higher authority somehow, we managed, and yesterday only we have filed, but whether we have, it has been scanned and given in the record, I am not aware of, your lordship. So if your lordship will still want to proceed with, I am ready to argue the matter, but I have the copy.
it can be fixed at 2 in that case, my lord. Because the impugn here is annexure A15. where after I'm being released on bail, again, production warrant issued and I was rearrested before I could furnish my bail bond in the same case, in the same FIR.
All right, that two.
Obliged, my lord.
Objection for alignment. Call for the objection.
Obliged, my lord.
Hearing VA item number 18.
May it please your lordship. So this is a regular bail application, lordship, 52 days in jail custody, lordship. Case was registered under lordship kidnapping and wrongful confinement where punishment is prescribed for 7 years, lordship. Today 52 days in jail custody, lordship. Case diary was called for, lordship. In several locations, lordship say
Not received, lordship.
now lordship FIR lordship will find on page 13, lordship. Girl already been recovered, lordship. She was given Jimma to her parents, lordship. That order, lordship, will find on page 27, lordship. Because this case is pending on 13/5/2026, lordship. Thereafter, lordship, several days, lordship, case diary was called for and that could not be produced, lordship.
Their lordship, they had committed the mistake in giving the wrong case number.
That is initially, lordship.
Yes, thereafter it was corrected. So
Yes.
lordship saying that it is entirely our blame, that is not appreciated.
That was on 25/5, lordship, it was corrected, lordship. That order is there, lordship. After that, lordship, case was fixed on 1/6, then 12/6, now lordship 18/6, lordship. This lordship 52 days, lordship, already statutory period for investigation, lordship 60 days, lordship, considering the length of detention, lordship.
The two, lordship, I will take the instruction if charge has been filed.
All right.
Obliged.
Yeah, please, your lordship. My lord, in this case, up to date case diary was called for, my lord. Already 55 days, my lord, I have spent, my lord, and 60 days is the statutory period, my lord. FIR, my lord, page 13. I was, my lord, 3 days police custody, my lord. Everything have been seized, my lord. I will face the trial, my
So
lord.
here also you get the instruction if PS has been submitted. Two.
Obliged.
May I please, your lordship? Regular bail application, my lord. Today is the 30 days behind bar, my lord. And FIR space, my lord, start from 17. It's a very long FIR, my lord. The allegation is that the petitioner is the assistant manager of the informant company, and the informant company is a company, is a agency. They help to the non-financial banking institution by assisting, helping, and collecting EMIs, my lord. And allegation is that he collected the EMIs and not deposited in the company's bank. This is the allegation. And for a moment, lordship, relevant, all are relevant, but entire FIR, they stated my 3 bank accounts. They allege that money transferred to my accounts. Kindly come to the page number 28 and point number E, last point, my lord. May I read, my lord?
E.
Lordship. The investigation team, after examining location-wise operation under the Debojit Changmai's control areas, Tezpur, Nagaon, Johat, Golaghat, tabulated the total amount of misappropriation and fraud committed by Debojit Changmai at around 24 so and so lakhs, representing customers' collections and company advances misused and delivered by him. Whereas Mr. Debojit Sangmai, this is the petitioner, made a false representation from the beginning and in furtherance of his common intentions, since inception, he had no intention to return the collected money which was collected, deposited or transferred by company field executive into his personal account. Mr. Debojit Sangmai consistently making false representation and giving false assurance was made only to put the VGM to wrongful loss only at his gains dishonestly. The FIR is registered under section, my lord, 318, this is sitting, and wrongful restraint 3162, lordship. And in fact, this is the both the section below the up to 7 years, my lord, but no notice was served to the petitioner prior to his arrest, my lord. Lordship, may kindly come to the page number 34. This is the order of the learned court below, while bail application was presented before the learned court below, my lord. But come to the page number 35. This is para third. The IO, lordship, got it, my lord? The IO on being asked stated that notice under section 35 BNSS could not be served upon the accused persons as the accused person absconded when he was contacted over phone by the police and later on he was apprehended from Dibrugarh. That cannot be a ground for not serving 35(3) notice, my lord. And in fact, the case is completely based on the documentary evidence, my lord. And today is the 30 days in custody and police never seeking for his custody, my lord.
Lordship, the petitioner was entrusted with the responsibility to collecting the EMI and overdue amounts from various customers on behalf of this company, VGM Private Limited, Lordship. As per the company's established procedures, all customers' collections were required to deposit it only into the company designated bank accounts. Instead of depositing the collected amounts, the petitioner deposited the amounts in his account. Several accounts with the misappropriated amount is 24.28 lakhs. The account-wise details will furnish also already, lordship. The company shows that the 10,48,797 in the Axis Bank account for the petitioner, 4,80,000 with rupees HDFC Bank account. Several bank accounts were money was deposited, lordship, without depositing the amount in their company account, lordship. And he was asked to return the money. That's why he was promised to return the money, but therefore he played evading from the promising to pay the amount to the company. He played from the.
There was number of collecting agent, my lord. They have collected the amount, my lord. In fact, even assuming he has misappropriated money, that the informant company has available alternative remedies, my lord, to recover the money. That
does not make it a non-offense.
It may not be, my lord, but the clear violation of section 35(3), my lord, they never served upon the petitioner, my lord, prior to arrest.
Several approaches made by the company personnel to return money to
About 35.
Lordship?
About 35, lordship. His checklist was prepared. Arrest, lordship. In fact, forwarding it was stated that why 35 was not used. Lordship.
Where?
And in that 34 lordship, last para lordship, case 44, I have perused the case diary as well as the reasons of arrest enumerated in the forwarding report and also the checklist under section 35(6) of BNSA appended along with the case record. Also perused the grounds of arrest communicated to the accused persons in notice 47 and 48 lordship.
That is only checklist. What does the checklist say?
Yes. Number 35.
Has it been ticked?
What notice not in the area lordship. Notice was regarding 35(3). Otherwise, sufficient materials are against the petitioner lordship. Sufficient materials are there in the against the petitioner lordship only. Because the amount is huge enough, lordship. And in his confessional statement also he has admitted the fact lordship.
If you don't issue notice, you have to record a reason.
No reason is in the case I have not found anything lordship regarding reasons.
I am the informant, my lord.
Yes.
But what my no. The ultimate paragraph, my lord, is written, considering the materials on record, the court holds that the arrest of the accused is justified, my lord. Besides this part, my lord, is 24 lakhs rupees.
Now, what is the basis on which it is found justified?
That my lord will peruse.
Records are before us also.
My lord can peruse.
That is what we are doing for the last 10 minutes. Perusing to find if there is anything. Justifying non-issuance of notice. If you don't issue notice under 35, you have to record the reason that you have to arrest him. So 35 is not issued. If you decide that he is not to be arrested, then you issue the notice.
Only thing is that the facts, reasons, materials for justification of those points. Of checklist is the point, the justification points are in the checklist of it. That is the clear option. But otherwise, 35 notice is not issuing the 35 notice. No explanation is regarding that option.
Yes, anything else?
At this 35, I have also filed my
Hmm.
primarily on the ground that my lord can peruse for a moment. Paragraph page 33, there the forwarding report, my lord. The paragraph, actually it is paragraph 1, but it is on the ultimate, on the top of the paragraph, my lord. And then 4, my lord. Primarily, our concern is, my lord, 24 lakhs rupees. Page 46 of my objections, my lord. The petition, my learned friend has categorically stated that it is his personal amount, my lord, personal money, my lord. And we are on record, my lord, page 26, that how and this is the modus operandi of this man, my lord. And page 38 can be looked into for a while, then it will make it very clear, my lord, that how he has done this. He has created a web in our name, my lord, page 39, my lord, and all the account collected by the field executive directly going to his account, my lord. And we have mentioned 4 accounts there. As of now, my lord, we have comes to know that 24 lakhs rupees he has already been diverted to his personal account, my lord. My lord can peruse page 39, the paragraph 8, line
Whether
number
that
9.
account has been frozen or not? Is the money available in his account?
Still it is, my lord, out of this money, we have comes to know that he has also spent some money, my lord. As far as bank account, we have enclosed entire bank accounts collected by the IO, my lord. Probably my learned friend can also when I apprise this court about this banking transaction part. But as far as our account goes, my lord, we have comes to know that he has diverted his personal account, then second account, then third account, my lord. And how he has done this, my lord, he had created a banking web. Money was immediately routed from one bank account and then to the multiple bank accounts, my lord. Our concern we are concerned about our money, my lord. Initially, even though in their petition, they have said that it is a documentary evidence, investigation has completed, my lord. Our concern is, as far as bank statement goes, and bare perusal of this document, my lord, goes to show that he has misappropriated, my lord, this amount so far, my lord. And after the internal inquiry, my lord, it can go up, my lord. And that's the reason, my lord, we are objecting at this point of time, my lord. Beside this, my lord, in the petition, other than these 2 parts, my lord, it's a documentary evidence, and considering the length of detention, my lord, there is no other pleading as far as his this petition is concerned, my lord. So, my lord, on a sympathetic ground, my lord, what we are on, my lord, we supposed to get our money. We have entrusted him the responsibility with the field executive. 60 field executive is working under him, my lord. He has collected the money. Instead of depositing to our account, my lord, he has not only created a web in one account, diverted into the second, third, to evade this kind of auditing transactions, my lord. And now coming with this, my lord, because of the length of detentions, without considering that part, my lord, what will be the condition of these companies, my lord? My landed friend can apprise about this banking transaction part beside this, my respectful prayer will be at least some mechanism, my lord. It's not that
This is a bail petition. We can't give you mechanism here.
at least my landed friend can come up and say that at least do that.
I have already submitted the bank transaction. Okay? Only thing I have to point it out, Lordship, on page 35, when being asked by the IO on being asked stated the notice under section 35 DNSS could not be served upon the accused person, as the accused person absconded when he was contacted over phone. by the police and later on he was apprehended from Dibrugarh. That
That notice should have been sent to his address.
lordship.
You have to record the writing, record it.
And today
This is not required. He is required to be arrested. Is it not? That is what 35 says.
Yes.
All right, we'll see. Hand over the CD.
Apply.
May I please, your lordship? This is regular bail application, lordship. Allegation is 69 BNS, and I have completed 31 days behind the bar, lordship. Lordship, basic fact of the case that kindly see the page number 11, lordship. Actually, this FIR is too long, lordship. Basic fact of the case is that the accused and the victim were in love relationship, and they have been living together as a couple, lordship. As a result, she is now pregnant, 4 months pregnant, lordship. This is the main allegation, lordship. And lordship, at this state, lordship, I can take all the responsibility of the victim girl, and she is married. She was previous, lordship. She is previously a married woman, lordship. So I can, and that she is pregnant, lordship, right now. So I can, I may be allowed to go on bail that I can take responsibility of the victim girl, lordship.
Yes, how many days?
31 days, lordship. Mandatory period is 60 days, lordship.
I'd like counsel for the petitioner. LPP, this is an application under so and so. The brief of the case is that the accused entered into a physical relationship with the informant, who was a married lady with 2 children, upon a promise to marry her, and consequently she became pregnant. Thereafter, the accused fled and blocked the informant from all sorts of communication. Full stop. Accordingly, the instant case has registered. CD is received.
Yes.
The CD as called for has been received. It appears from the material in record that the petitioner was consensual relationship with the informant who was a mature married lady with children. Full stop. Regard to the above, as well as the fact that the petitioner has spent 30 days in custody. The prayer for bail is allowed. 50,000 to securities. Shall cooperate with the investigation, shall not try to influence or intimidate the witnesses. Problem, sir.
24 Lordship, petitioner is on interim, CD has not been received.
CD not received, interim order passed earlier to continue. Next, list again on
20 to 7. Updated CD was called for. Lordship.
that CD not received. List again on so and so, interim order passed earlier to continue. Date.
Right, 21 Lordship.
27.
Lordship, perhaps CD not received in this matter.
Interim is there. We are on interim.
Interim may be extended.
Same order.
April.
Second.
May it please your lordship. Lordship, this is an anticipatory bail application. Lordship will find the FIR that is on page 11, lordship. The informant and the petitioners are from the same family, lordship. There is a dispute, lordship, regarding electric bill. Out of spur of the moment, lordship, one lordship stabbed the another and they succumb to that injury, lordship. Subsequently, lordship, they have settled the matter, though it is not an compoundable offense, lordship. The informant shown an affidavit that is on page 16, lordship.
Yes, CD.
Yes, Lordship. CD has been received. The PM feels, Lordship, that cause of death was due to hemorrhagic shock. All the injuries were antemortem. Injuries were caused by sharp pointed weapon. He was repeatedly stabbed in the abdomen, Lordship. He died. There is also eyewitness to the incident, Lordship, who have clearly implicated the present petitioner, and it is the case of, Lordship, where compromise can be done. So for
Yes,
further
absolutely.
investigation, Lordship.
Compromise may be because of coercion also.
Yes, we do not know at this stage, Lordship. I praise, Lordship, in this bill application. Maybe, Lordship, repeated house searches has been made. He is absconding now, Lordship. I have placed on an eyewitness for your Lordship.
Heard learned counsel to the petitioner and additional PP. This is an application under the allegation against the petitioner is that he stabbed the victim and killed him over a dispute connection with an electricity bill. So, for the petitioner submits that a compromise has been effected between the parties. In this regard, an affidavit has been by the informant para learned additional PP with reference to the case diary submits that the accused killed the deceased by repeated stabbing with a knife, which is confirmed by eyewitnesses as well as by the post-mortem report. In a case of this nature, a mere affidavit of compromise significance full stop having regard to the heinousness of the offense. Therefore, prior's bail stands rejected. Send.
Highly obliged.
He has not been received.
Yes, your lordship. It is for the sixth time. City has been called for lordship. Kindly peruse the earlier order, lordship. Lordship, FIR was filed on 21/12/2025 and main accused has been already released on bail, lordship. Charge sheet has not been filed.
Where is this IO from?
Rupo here.
Hmm?
That previous case also.
Order has been communicated.
Yes, Lordship. 5 times we have sent the requisition, Lordship.
No, this as per last order, in the event of non-production of the CD, officer concerned shall remain personally present before this court.
We have communicated, Lordship. Communication.
All right, verified that. Otherwise, we direct the concerned CGM to issue NBWA.
Yes, yes. Personally present before.
Kindly,
Or we can direct him to be personally present before.
That direction is already there. That direction is already there. Unless CD is produced, he'll be personally present. So neither CD is here nor is he present.
Lordship, at 2, Lordship.
All right, at 2.
30, Lordship, petitioner is on interim, CD has not been received.
Already, same order, interim.
22nd July, Lordship.
May it please your lordship. Lordship, this is an anticipated bail application. This petitioner on interim bail, lordship. Case diary was called for, lordship. FIR, lordship will find on page 15, lordship. He is not named in the FIR, lordship. 2 persons were arrested, lordship, subsequently recovered from them, lordship. But police is searching him because in earlier case, lordship, He was arrested, Lordship, subsequently released on bail, Lordship. And anything happened, Lordship, this police is after this petitioner, Lordship, since previous case is there, Lordship, against him, Lordship.
This person was arrested, from whom the recovery was made.
Yes.
And the petitioner, who is he? He is named.
He is not named in the FIR, Lordship. In
I don't-
previous case, Lordship, in earlier case, there is a criminal antecedent against this petitioner. That's why, Lordship, when anything happened, Lordship, the police charged this petitioner, Lordship. That order reflected annex, Lordship, on page 22, Lordship.
Unless it is transferred, sold by representing it as genuine, will the offense be attracted? Many people can carry imitation jewelry, whatever.
Yes.
Yes, it is.
21 numbers of
Yes.
suspected gold, gold.
They may be for the purpose of decoration also.
Also, maybe. Here, Lordship, the issues are a bit different. Why I'm stating it, Lordship, subject to if they have finished their argument.
Yes, yes, yes.
This present petitioner, he was granted interim, he never till date. Second, Lordship, I'll just point out, Lordship, how many cases he is facing, Lordship, till now. And fake gold and fake currency cases are also pending again. One is, Lordship, Lakhimpur PS case 29 of 24. Then, Lordship, Bibuya PS case 96/23, that is for fake currency. Bibuya PS case 40 of 24. Bibuya PS case 244 of 25. And some other cases are there, Lordship. Lordship, they order, they have annexed in the bail application. Lordship will also kindly peruse that FIR. That order for a moment, Lordship, page 22. Kindly come to page 20. The subject matter of that bail application, Lordship will kindly.
Page 23.
23, yes, Lordship, bail application.
Yes, what about it?
23, Lordship, paragraph number 3, Lordship will kindly. Solduri so and so self is seen that on the date of incident, police visited the place of occurrence to arrest one Baharul Islam in connection with some case, but all the police officers were in civil dress and they also took private vehicle in place of a police vehicle. When they apprehended the accused Baharul Islam, he raised hue and cry, and lots of nearby people came and gathered there, as many people present there who were watching the cricket match in television. All the persons who gathered there had the impression that some person may try to kidnap one person, namely Baharul Islam, who made hue and cry, and with that intention, some of the people gathered in the place of occurrence where police arrested some of the accused person. Cannot be arrested also, Lordship. That's a separate issue, but Lordship, having so many criminal antecedents and being involved in this case also, Lordship, and he did not comply with your Lordship's direction as well. Till that, Lordship, he has not appeared before the IO. Interim was granted on the month of May, if I'm not wrong, Lordship.
Lordship, Well, Lordship, what happened, my learned friend has stated, Lordship, all the PS case, Lordship. Now, he has not stated whether the petitioner got bail on that case or not, Lordship. Then in maximum case, Lordship, so far I have instruction, Lordship, he has got the bail, Lordship. Now, Lordship, regarding the Lordship, and if he appear, Lordship, another case will be, Lordship, he will be put in jail, Lordship. Because one after another case is Lordship lodging against this petitioner, Lordship. They have not started, they have not confirmed, Lordship, how many cases pending against this petitioner, Lordship. If they can, Lordship, clear that how many cases pending against it, that I could approach for before this court for anticipated bail, Lordship, because they are implicate me one after another case, Lordship.
So police will give you a list of cases.
Lordship, unless Lordship, there how many cases pending, that has to, can Lordship communicate it to the court, Lordship. They've said those are the case, Lordship. Maximum case, Lordship, he has got bail, Lordship.
I have understood two things, Lord. Without a prayer being made to that effect, we ourselves will have to provide him a details. That is the first submission.
Because Lordship,
Second submission is, Lordship, even if he gets a bail, because of pendency in other cases, he should not appear before the police.
that is not my prayer, Lordship. One after another case, he was implicated, Lordship.
Have you mentioned? it
Because
to the-
Lordship, one after another case, that's why Lordship, he was trying to, Lordship, picked up the police in a civil dress, Lordship. That too, Lordship, without showing their identity card, Lordship. That's why he got the bail in previous occasion, Lordship.
Audacity of the present petitioner, Lordship, on the last occasion when the case diary was produced, we have made a prayer, Lordship, before the court, asking us to update the CD because we could not find the statement of the petitioner in the CD. He himself, been aware of the fact, Lordship, did not disclose it today also, Lordship, that he has not appeared.
That instruction I have to take, Lordship.
Lordship will kindly see the last order. We have updated the CD for statement of the petitioner, asking time, Lordship. And when we have updated the CD, I have also talked with the IO, Lordship. He has not appeared till date, Lordship. Having that knowledge on the last date also, Lordship, he has not appeared before the IO.
All the police cases relate to the same police station.
North Lakhimpur PS case is there and Bipuria is also there. Bipuria, Lordship, around three cases are there in Bipuria, one in North Lakhimpur.
So you have got bail in all these cases.
The case, Lordship, he got bail, Lordship. Let me ascertain, Lordship, which is the case, Lordship, he got the bail, but he got maximum of the case, he got bail, Lordship.
No, no, what will you do by apprising us? If you have got bail, you have nothing to fear.
Because Lordship, every time Lordship, when he got some interim protection from this court, another case is Lordship will be searching him for another case, Lordship. This is the way Lordship police is doing, Lordship, against this petitioner.
You take up. Because otherwise he would have no reason not to appear, having got the protection of the court. So obviously he apprehends that in some other case he will be picked up.
Lordship, that knowledge, on the last occasion, he had that knowledge, Lordship, that this statement is not there in the CD. So knowing that also, Lordship, he is not appearing, Lordship. What is the use of granting interim, Lordship?
At around 31 continued.
Yes, where were we? I think we need to have a practical solution to this. So we'll better ask them if he is wanted in any other case in that police station. Third learned counsel for the petitioner. Updated case diary is available. On perusal of the CD, it is submitted by learned additional PP that the petitioner, pursuant to interim protection granted by this court, has not appeared before the IO within the stipulated time. On the other hand, learned counsel for the petitioner submits the petitioner has not been able to appear before the IO due to his apprehension that he would be arrested in connection with some other case upon his appearance, comma, the particulars of which are not known to him. It is also submitted that he has been granted bail in some other cases. Registered against him, but learned counsel present does not have with him particulars of all such cases. We'll stop. Here are the
Lordship, the
under
present,
the
present case is registered at Laluk PS. Whereas the other details that I have received are of Lordship Bipuria.
he is going to Laluk PS.
Yes, that's
So
what
if he is arrested, he will be arrested in connection with some other Laluk PS.
Yes. That information is required, whether
Yes.
any case is pending in Laluk.
Laluk. That is all. We cannot ask Laluk police to get information about
Yes,
cases
that cannot
pending
be,
elsewhere. The aforesaid view of the facts and circumstances, comma. Additional PP will submit obtain instructions as to any other cases registered against the petitioner at Laluk PS. Is the matter again on so interim order passed earlier to continue till the next date of listing. Bless. Pending Link it on DD.
Standing at a 14.
Might be lost it then. See, I don't, the petitioner is in charge principal of the school, college. And he was external in the examination, man. One student got expelled. 133, my lord, 16. 2016, my lord. 16. Then thereafter, after expulsion, my lord, her mother came and filed an application after about, my lord, 5-6 days, my lord. Filed a case. 7 years. Then filing saying that, my lord, prior to the 3 date, my lord, on 2 days, my lord. Earlier 2 days, he has gone to her house. Then modesty, my lord, that was outraged. Then again, he attempted to rape. Then he again come to the, prior to the examination. Thereafter, this case was ultimately FIR was 6 years, 2016 date of occurrence. Charge sheet filed on 22, my lord. Now he was immediately police came and ultimately he was given on bail, my lord. Now my prayer is, my lord, that whether this it is continuation will make any fruitful result or the result will be the acquittal, my lord. Your lordship, if you lordship kindly see the FIR, my lord. He was external at that time, my lord, external in charge principal of the school.
Page
21.
Page 21, FIR. 7/3 to 16, my lord, FIR, your lordship. And date of occurrence, basically allegation, you have to kindly see the FIR, my lord.
Yes.
Now, page 17, he was, my lord, his order for external examination, my lord. His letter for external, page 17, 18. 18 is as far as external examination, another college, my lord. Another school, sorry, not college. So, 17, 18, 19, my lord. That is my letter for appointment of external examination in another center, not his own college. Control of examination.
He is professor of Ahmedabad College in Satya.
Yes.
And this incident took place where?
Another matter, it is in Jamardahat Center. Jamardahat, page 19, you also will see.
Yeah.
Page 19.
The victim is a resident of which place?
She is a resident of, my lord, that village, Balatari, Fokirgam. Fokirgam, my lord. And my village is, my lord, actually they have written it somewhere else. Page. In the FIR, you also will find my address was accused Professor so-and-so, college residence of village Satya. Satya. And the same police station, same, but
Same police station, I think.
same village is different. Now you'll also kindly see the date of occurrence, assuming it is correct. You'll also kindly see first incident is 14 to 16, then 19 to 16, then
who trees no FIR, no information to the police, not to anybody else? Why not? Not to anybody else also, no information given. Then on 3 occurrences took place and FIR was 73. Even after that 4 days, after 4 days, man. Ultimately, this is a case of acute order. I am on that mind. On the face of it. And delay has not been explained. And after 6 years, FIR made a charge sheet was filed. I'm relying on Bojanlal, my paragraph 7, my lord. Your lordship knows it. Last time, referring 24, 3 CC, my lord. Just relying that Bojanlal case here given, my lord, that is your lordship is aware of that. It's same under page 677. They have referred to Bojanlal, my lord. Yes, 7 guideline, that's 7 guideline. Page 677. Seven, my lord, clause 7. Where a criminal proceeding is manifestly attended with malafide and where the proceeding is maliciously instituted with an ulterior motive for wreaking the vengeance on the accused and with a view to satisfy also. And also, my lord, it comes to my lord, 5 also. Improbable. Continuous simply nothing but abuse of process for law. This is the.
Yes.
Authorization.
Yes, I've not been able to record, but I've seen online, my lord. The charges have already been fixed and the case is now. Yes, my lord. If the victim has been examined or not, my lord, that is one thing.
What is the name of the victim? Asma.
Oh.
My lord.
Asma.
Asma Khatri.
Mother was examining as PW1, my lord. Asma also not examined for that.
So to go other of the problem.
Stage when washing is short, they are not say arrive at a conclusion whether it will be a case of conviction or acquittal lordship. Only prima facie case. That in my respectful submission is already made out. Referring to Bhajanlal also, that point he has argued. For that lordship, that there is any malice or other intention on the part of the informant, that then they have to provide evidence lordship in that regard. That there was a malicious intent on the part of the informant. They are alleging that. So evidence has to be forwarded by them in that regard. At this stage, lordship, only prima facie.
PW1 evidence has been completed.
Yes. That
Who is
what
PW1 victim?
a victim, not the mother of the victim, informant. Next 20,000. 20%. Yeah, what's one?
So how can we determine the veracity of the allegation in this proceeding?
Cannot, Lordship.
No, madam, on the
It has
face
to
of
be
the FIR.
manifest. Hmm.
It's true, madam, on the face of the FIR, madam, your lordship kindly see the sequence of the events. What happened?
That also cannot be seen, Lordship.
No,
as
but,
per the-
but actually, that's why this matter, Bhajanlal and others, so again and again, Supreme Court is matter affirming the judgment.
General is clear, Lordship. Only the presence of a cognizable offense is enough.
No, malefic, I am saying that because she was expelled, that's why they have got matter, not a single whisper from from first occurrence. Not a whisper to anybody, madam. Neither to neighbor as per mother evidence, madam. Nobody was informed. Even neighbor was not informed. And an external cannot give the transcript also, madam. External cannot give a transcript.
But he can promise.
Madam? No,
He can promise.
external has nothing to do, madam, with that part, madam. Question part, madam. Question part, either principal of the particular headmaster of the school or they may have some, madam. External cannot have any access to that transcript, madam. In another school, madam, not from his school also. On the face, only because of the madam 3 days, they kept silent. After occurrence also, madam, after 4 days, they filed the case.
Whether the
No
case is,
explanation.
vitiated by delayed FIR,
So
that is
ultimately,
a
what
matter
is
of
the
trial, basically.
ultimately matter what to be the result by your lordship very much aware what to be the result. So
No,
if
I'm
it
not aware.
continues, I am being a principal of a college, madam. Naturally, it is nothing. I may have to face the trial also, madam. Whether any chance of conviction?
Let us finish the submissions.
So my submit that abuse of personal privilege if it goes on, madam. On the face of
Actuated by malice, basically.
yes, malice.
It is basically actuated by malice
Malice.
and vengefulness.
Yes.
Because she was expelled.
Yes, madam. Because there is another school, not my school, allegation of transcript was given. I do not have any access to the transcript, my lord. If you goes on, mother.
Any record of the expulsion?
I being external, my lord. External, I have expelled her.
Why did you expel?
The on 3-3. On 3-3-16.
Huh?
3-3-16.
Uh,
Third March 16.
No, why did you expel?
Because she was found by
Unfair
the
means.
hot-handed on the copying.
So is there
That's why
any,
expelled, my lord.
is there any documentary evidence to back that up?
No, expel, my lord, it is on record. Expelled.
She may have been expelled. That why she was
So
expelled.
expelled by me because I was
Any
external.
notice there?
No, that my lord, expulsion is on the expulsion matter. And expulsion can be done only if somebody caught red-handed or any other unfair means, my lord. Kept mum, my lord. RD also kept mum. Even after 4 days of the incident, they kept mum. Then thereafter, my lord, if you also kindly go through the mother's evidences, my lord, it appears that one of the neighbors is behind all these things, my lord. The mother evidence, my lord.
Yes, you can pass it on. We don't. I think it's not in the record.
So evidence, we can pass over, we are having, my lord.
W1 আছে নাকি? ঠিক আছে।
Or up to the records, my lord, that also maybe done. It is not there, man. Because that was done on 29/1/26, man.
এটালৈকে আছে। Time back. The record is of November.
Oh.
By now, many witnesses may have been examined also,
Because
don't
as
know.
they have stated, PW was examined in the month of January. Lordship.
129 once.
Even then now,
Midway.
6 months have gone. Likely victim has also been examined.
Yes, possibly. That will make it more tough for him, Lordship.
Manifestly attended.
Yes.
Nanapai.
Yes.
I am on that.
Manifest.
Since he has been expelled, they have lodged this
Yes.
false FIR. It should be apparent that this cannot be. Uh, All right, I heard Mr. H. Chaudhary Land Senior also. This will be also heard. Mr. S. Nawazlan, amicus, representing the respondent number 2. The and copy of the TCR has been received, but it appears that it was sent in long back in the month of November. It's submit November 25. Full stop. It is submitted that the PW1 was examined in the month of January 26. And by now, more witnesses have been, would have been for an updated record. Hence, call for the updated copy of the original. Okay. Vacation.
Along with the deposition of witnesses.
Along with the containing the depositions of the witnesses, if any.
27-7.
27-7.
Now 15.
May I please, your Lordship?
My senior counsel is in.
Lordship, law is there. Article 22 of the Constitution of India says, no person shall be prosecuted or punished for the same offense more than twice. Yes, I am coming to that. 233. 233 is the procedure adopted to be adopted by the magistrate concerned to deal with this case. But Lordship, constitutional provision is there. Then a person cannot be tried for the same offense twice, Lordship. Here, in the same court, the same offense is tried in 2 cases parallelly. This is my case.
Well, if you cite the Constitution, you better read the whole article properly. Let us now confine ourselves to PRPC or BNSS, whatever.
Yes, Lordship. Then, Lordship, 230.
This is under CRPC.
CRPC. No, Lordship. BNSS. BNSS 233. The procedure to be adopted by the magistrate concerned. May I read, my lord? CRPC, it was 210. Now
Yes, now you are very wise after you got the break.
No.
So basically it will merge. Complaint case will be tried together. I will dispose of, send it back to the magistrate to.
Have been brought to the notice of the court.
Already heard Mr. G. Chamwa, learned counsel for the petitioner, and Mr. Learned additional public prosecutor. Mr. Also heard. Mr. So-and-so appearing for the respondent number 2. The petitioner herein seeks quashing of the criminal proceedings bearing CR case number 164 public 2022 under section 498A pending trial before the learned SDJM North Salmara SDJM within bracket M North Salmara Ovaipuri arising out of complaint arising out of a complaint lodged by the present opposite party number 2. Dispute in the present petition concerns 2 parallel proceedings instituted at the instance of the opposite party number 2 against the present petitioner. Para. On 30/07/2022, the who had lodged the FIR, the wife or the father?
Yes, Lordship. Yes, Lordship.
What is yes?
Asmina Begum. Asmina Begum. Opposite party number 2.
Lodged by the opposite party number 2 herein. At Boitamari police outpost, which was registered as Abhayapuri PS case number 361 of 2022 under section 498 within bracket capital A IPC. Para, within a week, that is on 6/8/2022, a complaint case was lodged by the opposite party number 2 against the present petitioner before the learned SDJM North Salmara Abhayapuri, containing basically the same allegations, which was registered under sections 40, not registered, don't say registered, okay. In the said case, cognizance has been taken.
Yes, Lordship.
Section 406. IPC. Subsequently, by order dated 10/9/24, the learned magistrate also took cognizance of the offense under section 498A IPC against the petitioner. Para. After investigation of the Abhayapuri case number 361 of 2022, the police submitted charge sheet under section 498A against the petitioner. Subsequent whereto charges have also been framed.
By order dated 10/9/2025. Last
Order
page.
dated 10/9.
10/9/2025, the last page.
Under section 498 capital A stroke 34 against the petitioner and co-accused and the co-accused. Full stop. It is submitted by learned counsel for the petitioner that two parallel proceedings on the basis of the same allegations cannot be allowed to be continued against the same person. And accordingly, this criminal petition has been preferred, seeking quashing of the proceedings initiated on the basis of the complaint lodged by the opposite party number 2 before the magistrate. Full stop. Para. Section 233 BNSS provides as follows. Put section 233 BNSS, okay? Para, a perusal of the FIR and a comparison of the same with the complaint instituted subsequently by the opposite party number 2 would reveal that both are based substantially on the same set of facts. Under these circumstances, it appears that section 433 BNSS would be attracted, and therefore the magistrate before whom both are pending before the same magistrate.
Yes, Lordship, SDJM 2. Oh, sorry, SDJM M, not Salmora. Abhayapuri.
for whom the present case is, the complaint case is pending, is required to act as per the aforesaid provision. It is submitted that both the complaint case as well as the case instituted on police report are pending before the same court, that is the learned SDJM M South Salmara,
Not Salmar,
not Salmara,
not Salmar, Abhayapuri.
Avayapuri. Full stop. Accordingly, the present petition is disposed of with a direction to the petition and to the learned same, okay, as the same to proceed in accordance with section 33 BNSS. Full stop. The petition stands disposed accordingly.
Lordship, stay order passed earlier shall be vacated because final order has been passed now.
Yes, stay order if any stands vacant.
Deeply obliged, my lord.
Article 17.
May I please, my lord? My lord, this is an application under 528. Praying to invoke your lordship's inherent power. When I was
The
released on
question here is whether without cancellation of bail, magistrate
Yes.
could have allowed
Yes, allowed to re-arrest.
the
I was released on bail on 29/5/2026. That
Yes.
was on Friday.
Mm.
Saturday, Sunday, Monday was holiday. Second, they have come with an application on production because there was a direction by the learned special judge that they have to come as per the established procedure of law. Without cancellation of bail, they have filed an application for production warrant and to re-arrest. And on 2/6, the matter could not be heard because I was out of station. And third, that matter was fixed. On second, I was not allowed to even furnish the bail bond because I have taken an undertaking that I'll not furnish the bail bond till the matter is heard finally. Physically, I appeared before the learning special judge on third, that is 3/6/2026. There, the production warrants were allowed, then re-arrest was allowed. At 29/5/2026, the order passed.
Which special judge?
My lord,
Not before me. Not before me.
Why? My lord?
Which special judge does it pertain to? Which?
Oh, Miss Special Judge, that was on 3/6/2026.
Alright.
Learned Special Judge Abhijit
All right.
Abhijit Bhattacharjee. That my lord will find the impugned that it pays 150 NHR A16. The moment it is interfered, 29/5/2026 revives, then I can furnish my bail.
No, first let's see the original order of bail.
29/5/2026.
Page.
Yeah, there.
My lord will find case number, it starts from 126, annexure A13. I respectfully take my lord to the operative portion, that is, that my lord will find in page 130. That's the operative portion, 130. It says, in view of the aforesaid facts, if your lordship has found it, in view of the aforesaid, I'm of the view that though the time
Accuse this Asem Kanan.
Yes.
Singh.
Asem Kanan Singh.
Hmm.
In view of the aforesaid fact, I'm of the view that though the time interval between passing of the order at 12:30 p.m. and the arrest of the accused and so and so. There is no order for this court, but to hold the arrest was made prior to the passing of the order. As such, the same is illegal in without authority or jurisdiction of law. That is what the learned special judge has come to the conclusion. Thereafter, the condition was given. Then page 130.
No, what arrest was caused?
That I was arrested on a string of a production warrant. Before,
No, earlier there was order of CGM Kamrup.
yes, thereafter it was committed after addition of section 16 of UAPA. Then by the same order that Milord will find in page 135. 135, the last portion. In view of the above, though the today's order dated, the bail of the accused has been granted in view of the technical and procedural defects, depriving the liberty of the accused, CBI shall not be precluded from again approaching the court for issuance of production of evidence to seek re-arrest in connection, but by following the procedure established by law. So, without applying for the cancellation of bail, on second, they have filed NHA page 137, the production warrant. Then that was allowed on third, 3-6. Then after allowing that, I was producing and I was rearrested. Therefore, I have impugned the order dated 3-6 that Milord will find in page 150. If they come for cancellation of bail, I have nothing to say. But even before cancelling my bail, the production warrant was allowed. Even in Revati, where this particular reason has been cited, it also says that first we have to adopt the process of cancellation of bail.
This, the order itself says, is it not?
The order itself says, but the order says one thing, it can be, but that is within as per the procedure of law. As per the established, following the procedure established by law. The order says, so when, because they have not followed the procedure established by law, the procedure established by law is to cancel the bail because it amounts to review of each own order. They have got one step ahead. That's my humble submission, Milan.
But if you are released on bail, what is the question of production warrant?
My lord?
If you are released on bail,
I am released on bail on
there is
29th.
the question of production warrant. Production warrant is for people who are in jail.
Yes. Yes.
But you are released, is it not? Or are you there in connection with some other case?
I was here in connection with some other case, 3 cases.
So in this case, you are shown arrested.
I have been released on bail. And in this case, I have been shown arrested.
Then released.
In this case.
But you still continue to be inside.
I'm still continue to be inside in this particular case, not on other case.
No, after allowing, after this first bail order.
My lord.
Did you go out or were you still there?
I was there itself.
Because there was other case.
There were other cases.
So that is why production
No, no,
warrant.
on RC 29, I was allowed to go on bail, but I didn't furnish my bail bond. Now I have already furnished.
There are no other cases
There are no other cases.
because of which you were in.
Except this case.
Okay. So because of non-furnishing of bail bond.
No.
He is already in JC, in other cases.
No, no, no. This is the only case.
Okay, we will not get into that, but you continue to be in jail
I'm
for
still
whatever reason.
in this case.
So that is why production warrant.
Yes. My lord, I respectfully take my lord to page 148. That things will be very clear. Last 148. 148 annexure A15.
Yes.
My lord, last sentence, Sri so and so, that undertakes that bail bonds of accused are same canon shall not be filed in respect of RC 6, that is the present case, and RC 29, where I have already furnished bail bond on third itself, that was allowed. So now I am in behind the bar only in RC 6, that is instant case. And my lord, the production warrant was prepped for the same RC 6 where I have been released on bail.
Yes, obviously. So now where is the impugn order?
Impugn order, my lord, will find
150.
page 150, annexure A16.
Yes. Now what does this judgment say?
It says, para 19. Because here, the learned special says that it's a regular bail, and this is what? Bail means bail. All bails are regular. They can come for cancellation. And they can even come for rejection. Para 19 says, the principle, if your lordship is found, the principle enunciated in the aforesaid decision makes it abundantly clear that when an accused is enlarged on bail, police custody cannot be granted so long as the order continues to operate. In the present case, the accused appellants stand enlarged on bail by so-and-so, passed by the line which has not been challenged before any forum, and the grant of police custody in the face of an existing bail order would amount to indirect cancellation of bail. I have got an existing bail order that was given on 29/5 in RC6, in view of the above, the impute order so and so. See, it amounts to cancellation. In fact, the operative portion starts from 17 onwards, the discussion, but I'm just pointing out para 19.
Yes.
So the question is bail is bail.
Shall I start, Your Lordship? May I please, Your Lordship? In this case, Your Lordship, on 29/5/2026, one order has been passed by the Honorable Trial Court, wherein certain condition has been granted, and that is that bail was granted due to certain technicalities. That technicalities is that, Your Lordship, that is with regard to the, because he was virtually produced, and the person IO was sitting there in the jail, and after moving the petition, his petition was said to be allowed from the. So there is a difference of 2 minutes or 3 minutes. However, typed copy has released at 12:30. So they have taken that plea that before the order has released, he has been arrested. So because of these technicalities, which has been raised in the order dated 29/5/2026, he has been granted bail, and to that effect, the learned trial court has specifically said that this order has been granted due to technicalities. I'm coming to that only, Your Lords. At our page, our objection, 187, Your Lordship, in our objection. That was not granted on the basis of the merit, Lordship. 187. So these are the WhatsApp printout. Here, there is a video call that is of 45 seconds, Your Lordship. That is at 12:21.
This is between jail and court.
Yes, between jail and court. And he is the left side, it is of the court master. And this one is of the IO. So this is lasted for 45 seconds, and that is at 12:21. When IO has called him, there is a wait 10 minutes, sharp at 2:45, it starts from 2:33. So when he has moved on video call, that is at 12:21, Your Lordship, after hearing, admittedly, sometime what happened, the operating part are being pronounced. So operating part is pronounced that yes, petition is allowed. The moment IO has come to know, he has arrested him. However, at 12:30, typed copy has come out. So this plea, this technical plea has been taken by them on 29/5/26, for which they have been granted bail. Now, after that, again he has been produced by way of virtual means to take him under JC, to send him under JC. And to that effect, there is a, it is written here, I may be permitted to examine him in jail only on Monday, 246. It is requested as IO 246. Thereafter, he has been sent in JC. Now, there is a difference of, he said 1221, but and 1230. This is the difference. Typed copy has come out at 1230, Your Lordship. Definitely after passing the order orally in the open court, when a order has
No,
been
we are
pronounced-
past all that. That chapter is over. Bail
Yes,
was
Your
granted, it was taken as a defect and bail
Yes,
was
that is
granted.
defect and
That is
that
not
defect-
under challenge.
Yes. So while passing this order, I am coming to page number 126 of their petition itself. Their petition itself at page number 130. Accordingly, the present bail application is allowed. Accused Asam Kanan Singh is allowed to go on bail of rupees 1 lakh with the two sureties, each of the like amount, each one of which surety shall be government servant on the following terms and condition: that he shall not leave the state of Assam without prior permission, that he shall not abscond, that he shall be available during the trial, that he shall not make any inducement, threat, or promise to any person acquainted with the fact of this case, and that he shall not misuse the liberty. And sixth one is that he shall also refrain from participating in any criminal terrorist act which might erase the society at large. Now, in the same order, Your Lordship, after giving this condition, the alternative has also been given. So two-layer order is there. That at page number 135, Your Lordship, of their petition. In view of the above, though my today's order dated 29/5/2026, the bail of the accused has been granted in view of technicalities and procedural defect, depriving the liberty of the accused CBI investigating authority shall not be preclude from again approaching the court for issuance of production warrant, and to seek arrest of the accused in connection with the present case by following the procedure established by law. So this order has been given by the learned trial court consciously, looking to the fact that that order was not based on merit. However, this condition, so two alternatives are there. If he will violate the condition, or alternatively, the CBI has also allowed, even if he is not violated the condition, the IO is allowed to arrest. He has not been precluded from arrest. So there are the two alternative conditions are given in this. Either if he will violate, or in this way, that is the last operating part, that the CBI is not precluded from arresting because it is granted only on the technical ground. Now I am coming to the other factor you're not seeing. So in view of that, my learned friend has filed a criminal petition before this Lordship. This criminal petition itself is not maintainable. Reason, for all said and done, he is under arrest. So at the best, he could have filed a bail application. But this is a criminal petition. In criminal petition, it is not at all maintainable, because when he has filed bail application on 29, he got a bail, but he could not able to furnish the bail bond. Consequent upon which he was in the jail. When he was in the jail, definitely when he was in the jail, IO will take the production warrant. And on the basis of the production warrant, he has been produced and he has been arrested. And in other cases also, some RC9 is already there in the JC. Now, this is a by way of criminal petition. Otherwise also, this is not maintainable by way of criminal petition. And subsequently, on 15/6, charge sheet has been filed, Your Lordship. When the charge sheet has been filed, so they are supposed to first approach the trial court, if at all there is any technical problem. And all the records are there, trial court records are there. And since the learned trial court has passed this order with a certain reasoned order, so the same court will look into this fact, and whether after looking to the trial court's TCR, he can pass the appropriate order. Otherwise also it is not maintainable. That apart, Your Lordship, there is a CRPC, your lordship, 437. I'm coming to 437. 437. 437 is when a bail may be taken in a case of non-bailable offense, when any person accused of or suspected of the commission of any non-bailable offense is arrested or detained without warrant by any officer in charge of the police station or a peer, or is brought before the court other than High Court or Court of Session, he may be released on bail on following condition. Fifth clause, clause number 5th, I am coming here, lordship. 437 clause 5. Any court which has released a person on bail under subsection 1 or subsection 2 may, if it consider it necessary so to do, direct that such person be arrested and commit him to custody. Four 37(5). To that effect, the latest judgment I have, your lordship. अपना citation to need Diop Junior.
Yes,
Lordship,
para.
the para 34, your lordship. Wherein it is reasoned order in the last, it is there, but I am going through right from 34. Page number 14, your lordship.
This is a case where
Lordship.
after grant of bail, further cognizable and non-bailable offences are added.
Yes. So reason.
It is not the case here.
But I am coming to there. Here in the last line, it is there in 4th, your lordship. I am coming to, I am going through clause 3. The court, in exercise of its power under section 437(5) or 439(2) of CRPC respectively, can direct for taking into custody the accused who has already been granted bail after cancellation of his bail. The court, in exercise of its power under section 437(5) as well as section 439(2) respectively, can direct the person who has already been granted bail to be arrested and commit him to custody on addition of graver and non-cognizable. In the while production warrant, I have given the petition. Why I need his custody, I have given the ground, your honor. Those are all non-bailable. Non-cognizable offences which may not be necessary always with the order of cancelling of earlier bail. It is very clear, your lordship. The court, in exercise of its power under section 437(5) as well as section 439(2) respectively, can direct the person who has already been granted bail to be arrested and commit him to custody on addition of graver and non-cognizable offences which may not be necessary always with order of cancelling earlier bail.
What does it mean?
It is qualified. It is not required.
Huh?
It is not required. In case where an accused has already been granted bail, the investigating authority on addition of an offense or offenses may not proceed to arrest the accused, but for arresting the accused so as such addition of offense. This is a different. I am here with clause 3. It is very clear, your lordship. Graver offense, because IO has to, it has come to the knowledge of the IO that he has to get it, identify certain looted item, and with regard to the abduction of one officer, for that purpose, he has given in the ground that why he need the custody. Why he need the custody, that is very clear in the ground of the petition, your lordship. I am coming to that, your lordship.
Here part it is said after cancellation of his bail.
But clause
part it says.
Clause 3 says.
These last two lines are not very intelligible to me. What is the meaning of it?
Sir, which one? In which surplus?
An addition of graver and non-cognizable offences which may not be necessary. What may not be necessary? May not be necessary always with order of cancelling of earlier bail.
The investigating authority on addition of an offense or offenses may not proceed to arrest the accused, but for arresting the accused on such, this is relating to different, this has been distinguished by clause 1, 2, 3. I fall under 3, your lordship. This has been distinguished, the positions has been distinguished. Under what circumstances, which action can be done?
Oh, yeah, the 3 that you rely on there itself in the first line, first sentence,
Yes, your lordship.
rather. It says that can direct for taking into custody the accused who has already been granted bail after cancellation of his bail.
But thereafter again it has been clarified, your lordship.
I don't know if it is a clarification or what.
No, the court in exercise of its power under section 437(5) as well as section 439(2) respectively can direct the person who has already been granted bail to be arrested and commit him to custody on addition of graver and non-cognizable offense.
So in your case, is there any addition of graver or non-cognizable offences?
It is given in the petition, your lordship. In 130.
No, at that time you applied for production warrant and this impound order was passed. Was there any addition to the existing charges?
No.
At that point of no section was imposed, but for the purpose of.
That is what this second part of para 3 relates to that only.
But for the
When
purpose of
it means reading the para 3 as a whole, it means that he can be taken into custody who has been granted bail after cancellation of bail. Secondly, part is that if graver other offences are added, then cancellation of bail is not necessary. He can be taken into custody. Because these are new charges. Bail was not given for those charges. So that is the combined meaning of para 3.
In the ground we have taken, your lordship, in our petition.
What ground?
That certain graver
When? That is our specific question. On the date of passing of the impound order, was there any graver additional charges?
Yes, I am coming to that, your lordship. 130.
That did not exist earlier.
I am coming to, yes. Our petition is 137. It is annexed with their petition. Page number 139, reason has been given. Why it is required?
No, you answer a specific question.
The accused has been arrested by so-and-so. The accused Assam Kanan, having the knowledge of other perpetrator behind such loot of large number of arms and ammunition in the instant case.
No, madam, just tell us on the date of granting bail, what were the charges against him? Under which section was the case registered?
On the date of?
Date of bail.
Coming to that, yes. That is at 29 year lapse. That was registered on 147, 149, 151, 395, 447, 457, 457, 458, 34. And thereafter, section 16 and 18 were added in the month of February. In the month of February, your lordship. Another sections were added in the month of February, that is on 23/2/2016. Additional section added by the order dated 23/2/2016 of UAPA Act. And your lordship, on the date of this order, it has come to the knowledge of the IO that he was influencing the person. I'm coming to that, your lordship.
Original order of bail was it page? Yes, this one.
Page 126.
No, what were the charges? Where is your arrest memo?
Beg your lordship. This is in the charge sheet. it
The
has
date
been-
of the bail, what were the sections against you? There are many accused
Yes.
and
What,
separately they are against them in this order.
uh,
A1, A2, A3 separate charges have been shown. Charge sheeted. They are charge sheeted.
to know.
12/1/24 charge sheet was filed. Then in course of investigation, 17/1/26 you were arrested. So what is the charge against you? Section?
Arrest you. Right.
Supplementary charge sheet 249 may kindly be seen, your lords.
Page
Page 249,
of yours.
our objection. Two 49. In respect of A8. 120B, 143, 148, 353, 382, 395, 440, 447 of IPC, Section 25, 1AB of Arms Act, and Section 3 read with 4 of PDPP Act, and Section 16, 18, and 20 of the UAPA. And the charge sheet has, this supplementary charge sheet has already been filed on 13/6, your lords.
13/6 or 13/3?
6. Only few days back, your lords. Page 252 will reflect the signature of the IO and the head of the branch with date. Now I try to bring to your lordships notice one page, our annexure 3, page number 188, your lordship.
No, you were arrested on date of
17.
arrest.
17/1/26.
So where is 17/1/26? At that time, charge sheet was submitted when?
13/6/2026.
Supply.
There was an extension.
Extension of
Yes,
time was
in
granted.
between.
All right.
18.
Charge sheet was submitted, your supplementary against you. That charge sheet is dated
13/6/2026.
13/6/26. What is the date of the order of bail?
29/5.
29/5.
29/5. So as on 29/5/26, under what section you stood arrested or granted bail? That will be revealed by the arrest memo.
Arrestment.
Case number 35.
Hmm.
This is a arrest memo. Because under normal IPC sections, then Melody will find serial number 9. And UAP were added, therefore extension was given for another 90 days after addition of UAP.
When was it added?
23rd to 2026.
Yes, arrest memo, then on that, these are the sections there, and which date was it UPA added?
Yeah,
23/2/2026.
23 to 6 UAP added.
And time is extended on 10/4/2026.
That is not in dispute. UAP added. So these charges mentioned in the arrest memo plus the UAP charges were the sections present and existing on the date of grant of bail on 29/5/26.
Yes.
So, and when was the production warrant issued?
3/6.
3/6.
3/6. So, after 29/5/26 and till 3/6/26, was there any other charge added?
No.
No, Lordship.
No. So, para 3 goes.
But I'm trying to bring to your knowledge, your Lordship, this page number 188 of our objects. Annexure 3. This is written to the Superintendent of Police, Imphal East District from Inspector K.H. Bombacha Singh. Subject: information regarding undue unnecessary approach being made to the undersigned by some unknown person regarding. It is submitted that the undersigned is presently posted as an inspector at Reserve Line, Imphal East. Undersigned is in charge at Reserve Line, Imphal East. I want to bring it to your notice that one Asim Kanan Singh, earlier working in the Manipur police, who was arrested by CBI in their case, and for the purpose of investigation, CBI has been regularly seeking information regarding him, as he was posted in the Imphal East district. I further submitted that since last week of February, the undersigned has been approaching by the family member, known person of said accused, and are trying to contact me through various sources. They are trying to pressurize me to not to give any documents or information or statements regarding the presence of said person from duty on 4/5/23. So this is his absence. I am bringing to your Lordship's notice again that he was absent on that particular date. 258, page number 258, your Lordship.
Absent from where?
From his duty, but he said, I was in duty. He's taking the plea that because he was a police
What has
person.
that got to do with the issue we are dealing with right now?
But this is.
You are only on, they are only on this limited point.
But he has also influenced, indirectly is influencing the witnesses and other person and pressurizing. This
Very
is
good,
the letter
very
of
good
two
ground for
states.
cancellation.
But at that point of time, he was in JC, sir. Not. And because of that due to technicalities, he was granted bail. Because of that, were two alternative has been given by the trial court. We have opted for that only, looking to all this scenario.
Yes.
And they have come for the criminal petition. Otherwise,
Let's not jump from one issue to another without resolving the first. You were since you were relying on this decision. What was that?
Sumit.
Yes, Sumit. Yes, you are relying on Sumit
Yes, sir.
on paragraph 3. So, okay, that part is over. Since this is not a case of addition of charges. So, as per that, application for cancellation is required, but your argument is that since the court itself had permitted you to approach while granting the bail order, so there was no illegality in that.
No illegality.
And that order was not under challenge. Yes. And according to you, that order said as per procedure.
As per procedure.
And procedure means cancellation.
Cancellation.
Or procedure for filing of production warrant application.
Lordship, procedure also
Procedure is not filing of products. Procedure is to cancel the bail and to apply.
The procedure also says that I can file an application for the production. That is also a part of procedure. Without that, it is not possible. And now he is under arrest.
Procedure obviously means procedure concerning filing of production warrant.
Yes, your lords.
If it had been relating to cancellation of bail, that need not have been mentioned also.
Given by the liberty, by the court. Two alternative I have been given. Either if he violate the condition, of course he has violated the condition on 2(6), influencing, that is also there. And I have followed the procedure, that production warrant, because the honorable court, trial court has given me that liberty. Had there been no liberty, I would have never filed that application. Two liberties are given me.
Yes, go on. Next.
So in view of that, this petition is not maintainable.
Yes, what about, yes, no.
Lordship.
Maintainability is a different issue. Why do you say it's not maintainable?
And now the charge sheet has already been filed. They can approach there.
No, it's not a question of whether they can approach there. It's a question whether they can approach here or not by way of this petition. When you say it's not maintainable, you must say why it's not maintainable.
Not maintainable here. The charge sheet has already been filed, and the competent court, trial court, because the TCR is lying there and looking to the merit, because this verbatim is given because of the technicality, it is granted. So as such, the court below is they can see the merit of the case and whether at this stage bail can be granted or not. Trial court can evaluate
Their question is not with charge sheet. They are not challenging the charge sheet or whatever. That will is a question of consideration of charge. They can argue that out whether the charges are attracted or not. They are not challenging the charge sheet here. They are only challenging the legality of an order.
But in our view, there is no illegality in the order passed by the.
They're not maintainable then.
No illegality, and we have right.
You can say there is no illegality, but you are harping on maintainability. That is the question of the court. Why is it not maintainable?
There is no illegality, your lordship, and now he is under custody. So by way of criminal.
It should have been a revision petition if you are challenging the legality of the order.
Here,
not a criminal petition.
I have challenged under criminal petition to invoke inherent power of this honorable court, because here I am challenging is an order to invoke, because it's an order and for the ends of justice, because the order 29/5/2026 says they have to come as per the established procedure of law. When somebody is granted bail, the established procedure of law, production warrant, re-arrest can be done, because after a bail is granted, there are two options, either for coming for rejection of the bail order or for cancellation of bail. One depends on the supervening circumstances, other on the perversity. Now, here, as per the stuff, if a bail is granted, and you do as per the procedure of law. So as we understand, the established procedure of law as settled by the Supreme Court in Catena of judgment is, first you go for cancellation of bail, then re-arrest me. Now, the question is, on the day when the production warrant application was filed, there was no changes in the circumstances, because bail was granted on Friday, then Saturday, then Sunday, Monday was again holiday, Tuesday they have come with this production warrant saying that a liberty was granted. My only humble submission before your lordship is that the procedure established by law as settled by Supreme Court is first cancellation of bail. That is what we understand with my limited knowledge, that is the procedure. Therefore, I have approached this honorable court for invoking inherent power, because that's an abuse of the process of court and for the ends of justice and for other things. That's my humble opinion so far, coming under the criminal petition nomenclature. And now an order of bail has been granted, and 29/5, once this 3/6 order goes, if it is interfered, 29/5 order survives. There I can furnish my bail bond.
It is all right. If this order goes, then you can furnish your bail bond.
I can furnish.
First, two questions. Why not a criminal revision petition? If it is the question of legality of the order, you have come by way of a criminal petition.
Yeah, I have come because inherent power
When
can be
statutory
exercised.
power is there, where is the question of invoking inherent jurisdiction?
No, for the ends of justice, because I see justice has to be done. For the ends of justice.
I'm coming to their prayer, Your Lordship, at page number 28. Lordship, their prayer is call for the record, quash and set aside the impugn order dated 3/6/26 passed by the learned special judge Assam Gauhati in petition number 609 of 26, whereby issuance of production warrant and rearrest of the petitioner in connection with the RC 6 ACB CBI Kolkata dated 9/6/23 came to be permitted. Third is quash and set aside the consequential proceeding arising out of the pursuant to the order dated 3/6 in connection with the so-and-so. Direct the order dated 29/5/26 passed in Miss case 26 to be given effect. This is in criminal petition. And as such, since two liberty has been given to the IO, IO has adopted one liberty. Order is reasoned order. There is no vague, neither it is perverse.
Yes, that is all. Heard, CAB.
Ending 18.
Obliged, my lord.
Much.
May it please your lordship. 52 days to the lordship.
I've taken the instruction. I've been told, Lordship, that a prayer has been made before the concerned court for aiding section 4 of POCSO. Section 4 of POCSO, a prayer has been made to aid the 4 of POCSO in the case, Lordship. Days, Lordship.
52 days.
2 days. Next week, if Lordship allows me to produce the case diary, then the victim statement may be seen, Lordship.
Already, lordship, several date has been given, lordship. There on 25th, 22nd 5, lordship. The case number was corrected, lordship. Thereafter, lordship, this
One date.
thereafter, lordship, it is fixed on say 1/6, then 12/6, then lordship 18/6 today, lordship. Till date, lordship, only section 143 and 3 subclause 5 of BNS, lordship. It's a
14 years girl, Lordship, section added, Lordship.
that was not done, lordship.
It is a statement may be taken by your Lordship.
165, lordship, 60 days offense, lordship.
If prayer has been, that is the instruction, prayer has been made for section 4, it will automatically go to 90 days then.
Till that, lordship, they have not, that could be placed by case diary, lordship, that they have not placed the case diary.
Yes, when can you place?
Next week, Lordship.
Already then, lordship, 60 days will be over, lordship, because they could produce it today also, lordship. Even if it's added that
No, it's
with that
52
prayer,
days, how will it be over? Monday?
Monday.
Today is Thursday,
Yes, Monday, Lordship.
it will be 56 days.
22nd.
Yes.
only specific on the trigger, whether that section is added or not.
Learned
It's
counsel for the petition and learned additional PP. Submits on instructions received that prayer has been made to add section 4 of the POCSO Act. The CD is not available. Here. Submission of the CD along with information there order has been passed for adding section 4 POCSO Act. By
On Monday, Lordship. Publish.
Ending 19.
60 days offense, my lord. I have already completed 55 days, so I may be allowed to on bail. I'll face the time, my lord.
is the offense.
My lord, 420, sitting and my lord, a criminal piece of trust, up to 7 years punishment, my lord, magistrate tribunal, my lord. I will face the trial, my lord.
All right.
Or for the TCR, if they are insisting on. Last to be.
No, you apply for you. What? You will apply for bail there.
Lord, yes, my lord, I can apply.
You apply there.
Observation.
Counsel for the petitioner and learned additional PP. It is submitted that CS has been submitted by CS number so and so learned counsel for the petitioner. That the petitioner shall apply for bail before the learned court below. And petition stands that in the event such bail application is filed as per law.
Number 190/20, dated 11/6/26.
Accomplishment.
Ending 29.
Is your lordship? Next time.
What instruction?
The instruction that charge sheet has already been submitted.
Case number 1 is a release on bail, lordship. Lordship, may kindly hear our interim prayer, lordship.
One 103 is there. We have to call for TCR, I think.
Kindly consider our interim, lordship.
Interim 103. After charge sheeting. How is it possible? Where is the FIR?
At page 18, lordship, vernacular.
It means the patient died. Person died.
That is why.
It is seen the report of the IO dated 18/6/26, wherein it is stated that the charge sheet has been submitted under section 118 within bracket 2/3 within bracket 5/103 within bracket 1 BNS. By CS number 65 of 2026 dated 21/03/2026. Call for the scanned copy of the.
Lordship, kindly allow us to appear before the below.
Are you sure? This is a murder case. Magistrate will grant you bail. Huh? What?
Call for the record.
Yes. Call for the scan copy of the TCR along with the CD. List again on. 16 July. Case number 32.
May please, your lordship.
I think here the office note dated 15th bills that service report has been received. Tag A. Needs to be. The 376 case.
366 and
All right. Hard run it counsel for the petition and additional PP. As per office note, service on respondent number 2 is complete, however, none appears. So and so is appointed as amicus to represent the respondent number 2. Next, copy be furnished to the newly appointed amicus. Please, pretty does. List again on. Scan copy of TCR already received.
list. Hey, please, lord. Period bail application, my lord, CD was called for petition on interim, my lord. And in term of the interim order, petition appear of the IO, my lord. The affair is, my lord, 8. Also was found an affidavit, my lord, regarding the of the other, this affair was lost, my lord.
Hmm?
Tabled in terms of lordship speech. And Lordship, this
What
gentleman,
is,
the flag mark, second flag, Lordship will see.
what is the meaning of this? তোমাৰ লগত কিবা হৈছিল নেকি? সব মিলি গৈছে। নাই, সব মিলি গৈছে।
I,
নাই, সব মিলি গৈছে।
there was a meaning, Lordship. Yeah. She's a disabled girl, Lordship.
Disabled in what way?
Speech, this gentleman is a next flag.
মই মাৰ ওচৰত।
The second flag, Lordship will kindly see. The petitioner.
This flag mark does not relate to the present
No,
victim.
no, it does not. So, Lordship, that is a girl.
Yes, yes.
The other witnesses also, Lordship, same type of.
Influence of the other person, who is the my lord, conflict between the land dispute with the present petitioner, my lord. So it's shown in the affidavit also, my lord, regarding this, my lord. My lord, kindly see FIR, my lord, the allegation, my lord,
What
similar
affidavit has been shown?
by the informant, my lord.
Where?
My lord, regarding this case, my lord. But for I clearly stated regarding the man of one man. Government man of from this.
So this is also solved. You are very good at solving cases.
And my lord, FIR also. my
1,
lord,
2, 3, 4, all cases are solved ultimately. Heard petition under PP. None for respondent number. This was not POCSO. Allegation. The petitioner is that one night when the victim, who is a speech impaired girl, Aragutu, was sleeping in her house. The accused petitioner entered the house and had forcible physical relationship with the victim. And she raised the alarm. Her mother woke up, because of which the accused fled. Had the accused petitioner had earlier committed similar bad acts with the victim. Full stop. Era. The CDS call for has been received. Upon perusal of the statement of the victim before the magistrate, the allegation of forcible sexual intercourse is not borne out. Affidavit has also been submitted by the informant, stating that the case was lodged against the petitioner out of misunderstanding. Full stop. Having regard to the above, the prayer for pre-arrest bail is allowed. The order of interim bail dated 26/5/26 hereby made absolute. Subject to the same conditions as may be applicable. Same
Hello.
like CD.
Five.
Has appeared and recorded.
Yes, my lord. Or have appeared as per the order of the Honorable Court. My lord, the allegation is that we are running a school without renewing the permission. My lord, what happened after the delimitation of the Hojai district and the, my lord, Nagaon? We have not filed, and now I have already applied, my lord.
What was the allegation?
Allegation is page 12, my lord. With reference to cited above, I have the honor to submit a detailed report of the United English School, Belwari, UDI's code number such as which is a private school. A joint inspection was conducted by the undersigned along with the block elementary education officer, Kothiatoli, to verify the physical existence and the operational status of the institution. During the visit, it was observed that the school is physically functioning in the Beloguri area under Hojai district. However, as per the available records, the institution is presently shown under Kothiatoli block of Nagaon district. It is further reported that the school was initially established under the jurisdiction of the Inspector of Schools NDC Nagaon.
So is the authorization there? Some permission is there?
Yes, permission, but after delimitation matter, I had to apply renew of the vision into the Hojai Inspector of School. That was not done. We are running the school with the old permission. But now we have applied, my lord.
Yeah, Lordship, 35(3) notice was served upon me.
They appeared.
Appear, Lordship.
Order dated 26/5/26, where 1, 2, 3, 4. Pursuant to interim protection granted, and also upon receipt of notice under section 35 BNSS, the petitioner has appeared before the IO and his statement has been recorded. Having regard to the above as well as the submissions of learned counsel, the prayer for pre-arrest bail is allowed. Order of interim pre-arrest bail dated 26/5/26 is hereby made absolute. Petition stands allowed.
Obliged.
26.
It's submitted, Lordship.
May I please, Your Honor? Your Honor, FI is at page number 11, Your Honor.
What do you want to do? Charge sheet submitted.
That's it, sir.
The 1182 is there.
No, but nothing has been seized, Your Honor. No weapons have been seized, Your Honor.
No, do you want to appear or?
Yes, I want to appear, Your Honor, CGM court, Your Honor. The lower court, Your Honor. I want to face the trial, Your Honor. Nothing has been seized, Your Honor, from us.
But can he grant you bail?
Yes, Your Honor.
Charge sheet has been submitted under what original section? Grievous hurt is there.
Attempt to murder is also.
1182.
Nothing has been
Attempt to
seized.
murder is also there.
Nothing has been seized, Your Honor. No weapons have been seized, Your Honor.
We are not discussing on merit. Will the magistrate grant you bail? What do you want?
We'll file a fresh criminal petition, Your Honor. Yes, Judge. TCR, Your Honor. Yes, Your Honor, TCR maybe call, Your Honor. This facility is fine.
Yes, submitted by. For scan copy. Please tell them, see.
Dated 30/05/26.
May it please, Your Lord. It's a charge-sheeted case, my lord. Two FIR were lodged, my lord. One by against me, my lord, and one by my family members against the family members of the my lord informant, my lord. After charge sheet was submitted, my lord, page 35, my lord, a summon was issued to appear before the committing court, my lord. This is 366. It was a charge sheet was submitted, my lord. As the session tribunal, my lord, I have approached the session judge for a bail, my lord. That bail order, your lordship will find page 36, my lord.
So you have been granted bail.
No, my lord.
Hmm?
Page 37, kindly see, my lord. I was directed to surrender before the, my lord, trial court, my lord. Which is the learned session judge cannot, my lord. My lord, I will appear, my lord. In fact, my lord, by my counsel, my lord, I am appearing on 12/11, 11/2, I have appeared, my lord. But kindly protect me, my lord. I will appear before the learned, my lord, committing court, my lord.
Earlier, you had approached.
I
This,
earlier I approached, my lord.
Order dated 19/12/22. Is that it?
Yes, my lord. Thereafter, charge sheet was submitted, my lord. After charge sheet submitted, my lord, summon was issued. Page 35 is the summon, my lord. Summon to appear, my lord.
I was asked to appear before the committing court on 26/6, next day 12/11/2025. On 12/11/25, I have appeared. My lord, that TCR is there, my lord, through my learned counsel, my lord. Thereafter, I have filed a bail application before the session judge, my lord. Yes, 36 the order, my lord. Bail petition was rejected, my lord. I was asked to surrender. I will appear before the trial court, my lord. In any condition, my lord.
Here is arrived, we have to see on merit only now.
The difficulty is, Lordship, the victim's girl's statement under 161 is there. Her statement under 164 was recorded, but that is not in the TCR.
What does 161 say?
It's in Lordship.
The victim girl already, my lord, recovered, my lord.
Charge sheet has been submitted only under 366. Although she stated that yet possible.
Yes. 76 is not there, man.
Hmm?
76 is not there. Only 366.
When is the occurrence? 22.
Responding during the investigation stage.
After receiving of the summons, my lord, I have
As a major girl, it appears to be she left with him. It's vehicle. Third, Presidential Learned Counsel for the Pit and under additional LPP. This is an application under so and so. The TCR as called for has been received. Charge sheet. The case pertains to the year 2022. The charge sheet in the case has been submitted on 10 to, not 10 to 22.
29/10/2022.
Yes, 29/10. 20. Under full stop under section 366 IPC. Perusal of the material on record, it appears that the petitioner had earlier approached this court by way of pre-arrest bail application, which was disposed of with an observation that the petitioner self was the learned trial court. Full stop. Upon such approach being made, the prayer for pre-arrest bail was rejected. So, rejected by session judge.
Session judge, madam, page 36.
Session judge of
Ujai,
by order dated
7/4/2026.
2026. Hence, a fresh approach has been made by way of the instant arrest bail application. Para. Having perused the material on record, the fact that the case has been over long ago. Fruitful purpose will be served by the petitioner to custody at this. The prayer for pre-arrest bail is allowed. Released on bail of rupees 50,000 with 2 sureties of like amount. Court below upon his appearance. On the condition here before the learned court below within a period of 10 days from order, provided that the petitioner shall cooperate in the trial if one shall not try to influence or intimidate the victim or other witnesses in any manner.
Deeply obliged.
38.
Please, your lordship. Lordship, 482 application, my lordship. My lordship, this is charge-sheeted matter, my lordship. My lordship, during the course of investigation, I was available to the investigating officer. I cooperated with the investigation. It is also reflected in the charge sheet, my lordship. My lordship, the charge sheet is laid under section 329 subsection 4 and 75 subsection 2. My lordship, where petitioner has received summon from the Honorable Court of Judicial Magistrate First Class, my lordship. My lordship, petitioner is on apprehension that on his appearance, my lordship, while transmitting the records, my lordship, to the committal court, he will be in judicial, my lordship. As 75 subsection 2 is my sessions tribal offense. My lordship, so petitioners filed this application, my lordship. My lordship, petitioner wants to face the trial and he will regularly appear before the trial court. And during the phase of investigation, of petitioner has cooperated with the investigation, my lordship, which is also reflected at page 20 of the charge sheet, my lordship.
Yes, PP.
It is fixed on 4/7 or Magdi statement of charge sheet. It has been mentioned. Waiting during the investigation stage. Statement of the
But this is what section?
329 subsection 4 and 70.
What is 75?
Sexual harassment and punishment for sexual.
Not rape.
Harassment, Lordship. Sexual harassment, and 2 is any man who commits the offense. Clause 1 or 2 or imprisonment.
Heard learned counsel for the petition and learned an application under so and so for allegation made in the FIR. The accused person had entered into the house of the victim, who is a widow, and touched her private parts, including her breast, The TCR as called for has been received. The case has already culminated in the charge sheet, and it appears that the petitioner had cooperated with the investigation, because of which he was not arrested earlier. Having regard to the above and the fact that the investigation already over from the it may not be necessary to take the petitioner into custody at this stage. Accordingly, the prayer for pre-arrest bail is allowed. 1,002 securities. Condition to DD%.
Obliged, my lordship, highly obliged.
Directed to appear before the learned trial court within a period of 10 days from today. Huh?
It's fixed on
It is given.
7
4/7.
4/7. On the next date fixed, that is
4/7/2000. Obliged, my lordship.
Item 40.
service.
Maybe Lisa Lordship.
Hmm.
Lordship, service of notice has been already completed, my lord. Kindly matter may be fixed for admission hearing, my lord.
Service on who is the respondent? What is the matter? Okay, I'd learned counsel for the petitioner. Additional PP as per office note, service on respondent number 2 is complete. Hence, list the matter for admission.
Obliged, ma'am.
That's exactly.
And we have come for a application for suspension of sentence. Okay, where he was convicted under section 204 part 2, my lord, for 6 years and payment fine. Brought on the evidence, my lord, that he was kicked, my lord, as a result, the rupture of the small intestine, my lord. That the appellant, my lord, took money from the victim, my lord. The victim took money about 30,000. He was supposed to pay back, my lord. It was a quarrel, my lord, as a result. That evidence.
Oh, we had this yesterday.
Yes, Lordship.
I've got given a copy to PP also, my lord. The doctor has examined my lord, PW 53, my lord. He says that small intestine is lacerated and contents come out from the peritoneal cavity. And
I think one of the witnesses, PW4, I
Four.
think is
PW4,
indicated you.
So, Lordship.
evidence.
Huh? No, direct eyewitness is not there, perhaps.
After the incident, he has
So outside saw Nogan Gugoi punching and kicking Jitan Gugo incessantly. That is the line. Nearby house is that is the house of my brother. I have seen the occurrence myself, went to the house of my brother. And my brother came out and both of us saw coming out from
later but also, so Lordship, accused then went to his house and brought an axe in his hand and threatened to us to kill us with that axe. That part is also there, Lordship. So intention is clear in this the position of the PW4, Lordship.
But
An opinion of the doctor as per the postmortem report. In my opinion, cause of death of the disease is due to a coma as a result of perforation peritonitis of small intestine, Lordship, following blunt abdominal trauma, Lordship. Injury parts are also there.
Small intestine is each contains multiple bruises seen in small intestine, one lacerated wound is seen in ileum, and each contents came out to the peritoneal cavity, size 2 into 1, lordship. And bruise position also the multiple bruises on omentum and mesentery small intestine was found, lordship.
So these are all the impacts of the blows,
Blow,
kicks and
Yes, lordship.
kick, my lord.
no external injury is
No
there.
external injuries were there. Actually, in a cross examination, he said that it was a repairable if immediate treatment is provided to the patient. So I did not knew that such injuries is likely to cause death, man. That part is not there, man. Already more than a year I'm in custody, madam.
My only one thing is that being a male person, assaulting in a private parts of a person is a testicles, lordship. What will be the consequences?
Testicles not in intestine. Not testicles was all right. Testicle was-
Honorable Supreme Court also, lordship, held that CGFO part 2 the prosecution and need not to prove intention to kill. It's sufficient to prove that the accused had the knowledge that the act was likely to cause death, lordship. Knowledge can be inferred from the nature of the assault, the part of the body targeted and the forced use. Here is the forced and targeted is also here, lordship.
Because had it been case where he became unconscious because he was there, he went for job also, and he took treatment in the evening also. In the night only, his condition serious and he was brought to the hospital.
So the learned convicted person also learned here lordship. PW1, PW6 and PW7. When the evidence claimed that the victim had the disease had disclosed before them that the accused had kicked him on his abdomen on the day of incident, which resulted in severe abdominal pain, lordship. And PW3 and PW6 went to the house of PW3 and found the victim lying on a bed, breathing in pain, and while PW7 claimed that the victim, while being taken to the hospital, told him that the accused had kicked him at his abdomen, lordship.
Sentence is, I think, for 6 years
6
only.
years. For relying on judgment, lordship, it is lordship. State of Karnataka versus Muhammad Nazir and alias Babu, lordship. They made to object to suspension of sentence and this. It is clear that knowledge part that the act was likely to be caused death, lordship. What here
And there will be knowledge. So the injuries was there.
injuries, internal injuries there, na?
That's why
That cannot be assumed in.
He did not take treatment. He should have taken treatment immediately.
All right, let's see.
My only submission is that actually, had there been treatment, would have been saved, my lord. And he went to job also. There he got paid, and he took to phone to the pharmacist instead of going to a hospital for proper treatment, my lord.
Lordship.
Meeting soon.